Mr. Douglas.
May it please the Court. Good morning, Your Honor.
Good morning.
Your Honor, there really is, as I see it, no real basis to challenge the relevance of the sought information and the fact that, in fact, this information would be critical to a full cross-examination of Mr. Furman. I think, Your Honor, in this regard, it would be important to review not only the personnel files from Parker Center, but any relevant personnel files from West Los Angeles as well. I'm unsure whether the Court had the benefit of reviewing each of the separate personnel files last fall when the Court reviewed and visited this question earlier concerning Mr. Furman, but I specifically in this motion, this amended motion, sought to have the internal affairs investigatory files of each particular office because I'm informed that it is the practice of the Los Angeles Police Department to retain a personnel file at the local division level and a separate file downtown at Parker Center. There are, Your Honor, I believe, three areas of inquiry that I do not think there's really any dispute as to the wisdom of having an in-camera review. And all that we are seeking by this motion, again, is an in-camera review. I think that the Court can take notice of the record that was made in the other hearing, the challenges that were made there as to the propriety of examining the personnel file of Mr. Furman and whether or not there are issues of relevance that may be germane to discovery. The three areas that we are seeking, though, concerns an investigation that was published, that was conducted by the Internal Affairs Division after Mr. Tubin's article was released in the New Yorker magazine. The details of that investigation, Your Honor, will impeach witnesses who may well testify in the future, but may also be very germane to our attempts to further impeach witnesses who have testified in the past. I am struck, for example, that Officers Risky, Rossi, Lang, and Phillips were all present at the scene before the arrival or near in time to the arrival of Mr. Furman, and I am certain, or I suspect, that each of these officers were among the 14 or so that were interviewed in connection with that earlier investigation. I think it also very important, Your Honor, that the investigation over the possession of some cartoon or other picture that may have included a Nazi-like symbol or insignia is another matter that has some possible relevance to a full cross-examination of Mr. Furman. This information, as the Court is aware, came to everyone's knowledge through the District Attorney's Office, who informed both counsel and the Court of their awareness of this investigation. We were also informed in chambers of the DA's awareness of an investigation that occurred over statements allegedly made by Mr. Furman, suggesting that Mr. Furman may have had some intimate knowledge of Ms. Brown Simpson, or in fact portions of her anatomy. Clearly, both areas of inquiry are very germane to the issues that we have put forward and to the areas that the Court has already ruled is relevant. As to the third area, certainly, if in fact there is any proof that there was some personal contact or acquaintanceship between Mr. Furman and Ms. Simpson, that would be very probative in providing perhaps some bias or basis for bias or basis for some other harboring of ill will or motive against Mr. Simpson in particular. Certainly, if there is something to suggest that Mr. Furman was in possession of some Nazi-like symbol or other cartoon or another, in any other context, that also would be very relevant to our claim that Mr. Furman may well harbor certain racial attitudes or thoughts or opinions that might be contrary to a fair airing of the evidence in this case, and that might be very relevant to a jury's assessment of his credibility as a witness. I think that there is no challenge that these investigations existed. I think there can be no real controversy contravention, that in fact it is necessary for a full examination of Mr. Furman that we receive these documents. These are not matters that we're on a fishing expedition about or pulling out of thin air. In 2 of the 3 matters, we were informed by the DA's office that, in fact, these investigations had recently been completed and that the only mechanism by which the documents could be obtained would be by the filing of this motion.
Thank you, counsel. Mr. Walsh. Morning, sir.
Good morning, Your Honor. I have a couple of points upon which I agree with Mr. Douglas and a couple that I disagree. First of all, I certainly agree that it's appropriate to have an in-camera review of any documents which the police department might possess which bear on the matters raised by Mr. Douglas's motion. Second, I agree that this is a continuation of a previously held Pitchess motion, and that we are not challenging materiality. However, a determination of relevance, unlike Mr. Douglas's position, will be made by you in chambers pursuant to the provisions of Evidence Code Section 1043 and 1045. And assuming that there are documents which relate to the matters described in Mr. Douglas's motion, I have confidence that the court will make that determination of relevance after it has had the opportunity to review those documents. And we're prepared at this time to go in chambers at the court's convenience.
All right. Ms. Lewis, do you wish to be heard on behalf of the prosecution?
Only to say, Your Honor, that I am confident the court will find nothing within any of these files to be relevant to these proceedings.
All right, Mr. Tortolo.
Good morning, Your Honor. Basically, I'd echo what Mr. Walsh said. With respect to the personnel files, we have no objection to Your Honor, as we didn't have an objection in August, reviewing in camera in accordance with the Evidence Code, Detective Furman's personnel records. We didn't have a problem then, we don't have a problem now. As to the alleged rumors that are part of an alleged internal affairs investigation, we don't know anything about that. I only know what I read in the paper. One of the rumors was that with respect to the internal affairs investigation, Detective Furman has no information as to what those are about. I have no information. As Your Honor knows, internal affairs investigations, if one is taking place, go in a process. They interview different officers. To ask that the court order the Internal Affairs Division, the LAPD, to release whatever material they have as to an investigation that may be in process would be very unfair to Detective Furman, if indeed it was about Detective Furman. These are only rumors, unsubstantiated rumors. And I would say with respect to the personnel files, we have no objection to Your Honor reviewing those in camera. We didn't the last time. And I'm confident Your Honor will find there's nothing in those files that would be relevant to these proceedings. But to start digging into internal affairs in connection with an investigation that's in some stage of its investigation is terribly unfair. Wait until it's completed, if in fact there is such an investigation. But these are just unsubstantiated rumors that were floated up, and all of a sudden I read in the LA Times that the Internal Affairs is allegedly investigating rumors with respect to Detective Furman.
All right.
So I would ask that you deny the motion as to the Internal Affairs and that you would review Detective Furman's personnel records in camera.
Thank you. Thank you, Mr. Tortolo.
Mr. Turlow wasn't privy to the conversations in chambers which gave rise to the filing of this motion. But we were notified by the District Attorney's Office that there was an internal affairs investigation, and it had been hoped that the DA's office would be able themselves to obtain the results of that investigation at its conclusion. Once the investigation had been concluded, we were then notified by the DA's office that they would be unable to obtain the results of that investigation, save for by the filing of this motion. And it was not any rumors, but our being placed on notice by the DA's office that there was this investigation, that it had been concluded, and that the only way that the results would be released would be by the filing of this motion that instituted this procedure today. And we are specifically looking at the Internal Affairs Division and those records, and that was specifically identified in my request.
Thank you, Mr. Douglas. Ms. Clark, let me ask you, when do you anticipate, in the scheme of things, assuming that we finish Detective Lang today, when do you anticipate calling Detective Furman as a witness?
Mr. Darden informs me that he will be following Detective Lang.
All right. Mr. Walsh, then, what I'm going to do is I anticipate it will take us the remainder of the morning at the very least to conclude Detective Lang. We have not finished cross-examination. We have redirect, recross. Re. Okay. What I'm going to do, Mr. Walsh, is the custodian records present?
Yes, he is, Your Honor.
All right, I'm going to order that custodian records. Who is that person?
Sergeant Jack Rose, Your Honor.
All right, Sergeant Rose, I'm going to order you return to this courtroom at 12 noon with the personnel records that have been mentioned.
Yes, sir.
All right, thank you.
Thank you.
Counsel, I'll conduct the in-camera review at noon time. I'd like to start with the jury, get that done, and then I'll conduct the in-camera over the lunch hour.
Thank you, Your Honor.
All right, anything else? All right, thank you, counsel. All right, Mr. Cochran, Ms. Clark, anything we need to discuss before we invite the jurors to rejoin us? Ms. Clark? Ms. Clark? Anything else we need to discuss before we invite the jurors to join us? All right, Mrs. Robertson, let's have the jurors, please. All right. Let the record reflect that Detective Tom Lang is still on the witness stand. Good morning, Detective Lang.
Morning, Your Honor.
You're reminded you're still under oath.
Yes.
Mr. Cochran, you may proceed with your cross-examination.
Hope conclude, Your Honor. Good morning, ladies and gentlemen. Good morning, Detective Lang.
Morning.
At the end of the day, yesterday, we were talking about the meeting that had taken place, I believe, on June 14th, 1994, at the SID lab. And I'd ask you to refer to your chronological record, page 00007. Do you recall that?
Yes.
And in that meeting, you would indicate that you had conferred with criminalists Matheson, Wong, Yamauchi that morning at about the time or before the sneakers were turned over. Do you recall that?
I believe I conferred with Matheson, and Wong and Yamaguchi were present.
Now, would you be surprised to learn that the SID unit has never had a Mr. Wong in the last 17 years?
I don't know.
Would you be surprised to learn that?
Not necessarily.
Could you have misplaced and meant Fung when you said Wong?
Certainly possible.
Now, in fact, you did, in fact, see or talk with Mr. Fung that particular morning, did you not, of June 14th, 1994?
I may have.
Have you seen the property report with regard to the Reebok shoes that were turned over?
I believe I have.
Counsel. I want to place before you the property report. I think it's dated 6/15/94, and it It deals with item number 18 of evidence. And read that to yourself, and I want to ask you a question with regard to it.
Okay.
You read that?
Yes.
And does that refresh your recollection as to what time you actually turned the sneakers over to the individuals at the SID lab?
It states 8:30. I turned them over to Mr. Matheson at approximately 7 a.m. for an examination.
All right, and that was some kind of a determination to determine whether there was blood on those tennis shoes?
Yes, I'd requested that he do a presumptive examination.
And that examination, the presumptive examination, took only a few minutes, isn't that correct?
That's correct.
And then I think you've testified before that these tennis shoes were negative for blood, is that correct?
That's correct.
And so, well then, was that around 7 o'clock you did that?
That's approximately the time that I arrived and turned them over, yes.
All right, and then what happened for the next hour and a half or so, if you recall?
I wasn't there for an hour and a half.
So whether the property report indicates that it was turned over, received from Detective Lang at 8:30 on 1/14/94, is that correct?
I would say that it was received by the lab at 7 a.m. or approximately 7 a.m. and was probably turned over to Mr. Fung at approximately 8:30 as indicated by Mr. Matheson.
All right, and this report is a report done by Fung and Mazzola, is that correct?
That's correct.
And I perhaps should mark this report since I'm referring to it. The defendant's next in order.
Well, no,
10.
there's no foundations, not the way security.
1048.
1040, all right, D1040. All right, and so...
We're not talking about admissibility, it's marked for identification purposes.
And read this middle part here read that to yourself, with regard to the criminalists in the lab.
Okay.
You read that?
Yes.
All right. And you were aware that the item we're talking about, the Reebok, was in fact recovered by criminalist Fung in the particular lab on June 14th, 1994. Is that right?
That's what it states.
All right. Is that your understanding also?
I believe that's a figure of speech as far as being recovered. It was taken into his custody. I'd imagine you could say it either way.
All right, or received. Is that a fair statement?
Certainly.
All right. Can you tell us or describe for us the equipment that's kept in your vehicle when you go out to the scene of a homicide, such as plastic bags and things of that nature? Can you describe that for us?
I do have some plastic bags, envelopes, disposable rubber gloves. I believe we have an AIDS kit.
What is that?
AIDS kit for the recovery of syringes.
All right. Anything else you can recall?
Notebooks, pencils, flashlight, rules, measuring devices, measuring tape.
Now, you had several conversations with Ms. Ratcliffe, the coroner's investigator, on the morning of June 13th, 1994. Is that correct?
I had conversation with her, yes.
Can you give us an estimate of approximately how long you talked to her that morning while she was at the scene?
There were more than one conversation. It was off and on. I was doing other things, and I really couldn't say.
You have an estimate at all of how long altogether you may have spoken to her in all the various conversations, sir?
As far as strictly conversation,
Yes, sir, conversations.
it's very difficult to say.
Do you have any estimate at all?
I couldn't pin myself down to an estimate. Perhaps strictly conversation, maybe 15, 20, 25 minutes, maybe longer.
All right, somewhere 15 minutes or longer. Would that be a fair statement?
I don't know.
All right.
I just don't know.
And you have no notes which refresh your recollection in that regard?
As far as how long that I spoke with her,
Yes.
I wouldn't have anything like that.
All right. Now, yesterday we touched upon briefly the fact that your notes do not reflect any spots that resemble blood on the rear gate. Do you recall that?
That's correct.
And in addition to that, you did, in fact, a diagram or a sketch of that rear gate in your notes also, did you not?
Yes.
And you don't place any spots or any indication of any blood in your diagram in your notes either, do you?
No, I wouldn't have done that.
All right. So the answer is you do not have that in your notes. Is that correct?
That's correct.
Now, with regard to the scene at Bundy, and on one of the videos, we saw that at some point a sheet was either placed over the body or a sheet was over the body. You recall seeing that?
I believe it was a blanket, yes.
All right, and it was white in color, was it not?
That's correct.
And with regard to that, this particular sheet or blanket, do you recall whether or not that sheet was taken and booked as evidence?
No, I don't believe it was.
Was there one blanket or sheet for each body, or was it the same sheet for each for the two bodies? Did you have two sheets or one sheet?
No, there was only one sheet, and that was to cover the one victim from public view.
All right, and that was the Miss Nicole Brown Simpson?
That's correct.
And when that scene, the crime scene, was broken down, that sheet was just left on the ground, is that correct?
That's my understanding.
Now, it's important, is it not, as an experienced investigator, for you to attempt to preserve any possible trace evidence, isn't that correct?
Trace evidence, certainly.
All right. And trace evidence can be very fragile, isn't that correct?
It can be.
And so that we're clear and we're talking about the same thing, what is your definition of trace evidence?
Trace evidence can be hair or fibers or any other type of evidence, debris that may not be readily visible to the human eye.
And trace evidence can be moved from one surface to the other pretty easily, isn't that correct?
I guess that would depend.
And that might be particularly true of things such as hair and fibers, isn't that correct? That might come off a body?
It's possible.
Blood on a body can be wiped off if the body comes in contact with something of the nature of either a sheet or a blanket, isn't that correct?
It would depend on how that blanket or sheet were placed on the body.
But the blood could, in fact, come off on that, isn't that correct, sir? On a sheet or a blanket?
Overruled.
I wouldn't know. It would depend on if the blood were dry or if it were wet and how the blanket or the sheet was placed.
Right, but it's possible that it could come off, isn't that correct, sir?
I suppose it's possible, yes.
All right. In fact, in this case, there were, what you have testified about, blood drops, blood spatters on the back of Miss Nicole Brown Simpson. Isn't that correct? You saw at the scene?
Yes, I did.
Which were not preserved, isn't that correct?
That's correct.
Did you take any steps to make sure those blood drops were not wiped off by this blanket or sheet being placed over Miss Nicole Brown Simpson?
Yes.
What steps did you take?
To place the blanket very gingerly over the victim. When the blanket was removed, the blood spots were still intact, as evidenced by the photograph.
And when you saw this, when was the last time you saw this blanket at that scene that morning?
When I left.
And what time was that approximately?
Approximately noon, I believe, perhaps 12:15.
It's when you left to go downtown?
That's correct.
And at that time, and so that we're clear, that particular blanket, it was white in color, was it not?
Yes, it was.
And it was never preserved or kept or booked by anyone, as far as you know, of the LAPD, is that correct?
That's correct.
Now, I want to show you at this point now, sir, a video and ask you a couple of questions after it's shown. Sorry.
Which video is this, Mr. Cochran?
We dealt with it at the end of the day yesterday, Your Honor. Video of detective. Those two members of the Los Angeles Police Department.
Yes.
This is at the Rockingham residence, is it, sir?
Yes.
And who's that gentleman who the camera's focused on there?
It's my partner, Mr. Van Adder, and myself.
And is that you? What does that, stop it right there. What is that under your right arm there?
It's a pair of Reebok tennis shoes, size 12.
Those are the tennis shoes we've been talking about?
Yes.
All right. And the gentleman walking with the tennis shoes on his arm, that is you, is that correct?
Yes.
Are you leaving the Rockingham location at this point?
Yes.
And after you closed the door, did you drive off from the location at that point?
Yes.
And, Your Honor, I'd like to mark that tape, I guess, as defendant's next note, I guess, defendant's...
1049.
1049.
Is that correct, Mrs. Robertson? Sorry, all right, 1049.
Did you have occasion to discuss the contents of this tape with the district attorney since we were in court last evening?
The contents?
Yes,
No.
what was on this particular tape?
I've seen the tape many times. I haven't discussed it.
Okay, the question is, did you discuss this with the district attorney since we were in court last evening?
No.
Did not discuss it last night?
That's correct.
Not discuss it this morning?
That's correct.
And at the conclusion of that tape, after you placed those Reebok tennis shoes in the front seat, did you drive off?
Yes.
Did you go home at that point?
Yes, I did.
Did you see whether or not, it appeared to you in that video, those shoes were placed in any kind of a box?
Those shoes were placed in a box once I returned to my home and placed into the trunk of my vehicle.
When you got home?
That's correct.
I see. But you didn't do that at the scene there, is that correct?
As your tape shows, there was quite a bit of media. I was getting pushed and shoved, and my only interest was to get away from the media. That was done at my house.
I see. So when you testified about it before, you didn't tell us about the media, did you?
I didn't tell you about the media?
Yes, you did not tell us when you testified.
Objection, Your Honor.
Legal ground?
He wasn't asked.
Or
When you testified before that you placed the Reebok shoes in a box in your trunk that particular day, you never told us that you had placed the Reeboks under your arm and placed them in the front seat of your car and drove all the way home. Is that correct? Did you? You never told us that, did you?
I don't believe I was ever asked that.
The question is, did you tell us that?
I wouldn't have answered that.
oral.
Did you tell us that?
Could I have the question again, please?
Right. Did you at any time ever in the presence of this jury tell us that you had placed the Reebok shoes under your arm and placed them in the front seat of the car and drove all the way home before placing them in the trunk? Did you ever tell us that?
No, I believe I told you that I placed them in the trunk of my vehicle, and that's ultimately what happened.
Right. I'm asking you, did you tell us that you placed them in the front seat of the car, Detective?
I had absolutely no reason to tell you that, no.
And what is your answer? Did you tell us that?
No,
You did not.
no.
Did you see Mr. Fung at the Rockingham location at or about after 5 o'clock that afternoon?
I
on
did,
June
yes.
13th? You saw him there?
I believe so.
And you talked to him that afternoon?
I believe there was some conversation, yes.
Could you have given the shoes to Mr. Fung at Rockingham that afternoon, since he ended up getting them the next morning on the 14th?
He apparently did, but I wanted to take them to the lab and have them examined there. I wasn't aware Mr. Fung was going to be at the lab. Mr. Fung works at Northeast Station, which is some distance from the lab.
Well, Mr. Fung was the criminalist who had been at the scene collecting evidence, both scenes, Rockingham and Bundy, all day that day. Isn't that correct?
That's correct.
And you could have given these Reeboks to him. Is that correct, sir?
I could have. Mr.
But
Fung
you-
was a very busy man. I wanted
right.
these done, presumptive tests done at the lab and turned over at that time.
I see. I'm sure he was a busy man. The question is, you could have given these Reeboks to Mr. Fung on that Monday evening after 5 o'clock in the evening. Isn't that correct?
I could have, certainly.
And what time was it that, your best estimate, that you were getting in the car and placing these Reeboks on the front seat? What time was that?
I don't know, perhaps 6 o'clock.
On June 14th?
No, it would have been June 13th.
I mean, June 13th. And how long was your drive home?
Approximately an hour.
And how many miles is that?
It's approximately 36, 38 miles.
And it's your testimony that there was no way you could book the items, the Reebok shoes at that time of day because the property room was closed and you couldn't get a DR number?
Well, not only was the ECU closed, there was no DR number that had been obtained. The criminalist was booking the items, and they had to each be given an item number.
And with regard to a number of other items that recovered at Bundy and or Rockingham, the criminalists booked those items themselves, isn't that correct?
Yes, I believe in the 15th.
Right. But this one item you brought back the next day on the 14th morning, right?
That's correct.
Thank you very kindly, Your Honor.
Ms. Clark?
Detective Lang, let's talk about those Reeboks for a minute, sir. What size were they?
Size 12.
And were you aware of the size of the, are you aware of the size of the bloody shoe prints at Bundy?
Yes,
And what size are they?
size 12.
Now, the sole pattern of the Reeboks, as far as you know, did not match the pattern of the bloody shoe prints found at Bundy. Is that correct?
Sustained.
Do you happen to know, sir, whether the sole pattern of the Reeboks that you seized from Rockingham on June the 13th matches the sole pattern found from the bloody shoe prints at Bundy?
Yes, I do.
Sustained. Want to rephrase the question?
Certainly, Your Honor. The Reeboks that were pointed out to you at Rockingham on June the 13th, which you took into custody, are you aware of whether those sole patterns matched the sole patterns of the bloody shoe prints found at Bundy?
Yes,
And do they?
they do not.
Now, who pointed those shoes out to you?
Mr. Simpson, the defendant.
And pursuant to what? How did he happen to point them out to you? Did you ask him a question?
I asked Mr. Simpson if he recalled what shoes he was wearing the previous evening, and he pointed them out and stated he believed that those might be the shoes that he had on.
And based upon that, you took them into custody.
That's correct.
But in fact, the pattern did not match the shoe print at Bundy.
It's
Foundational.
fleeting.
But the shoe pattern of the shoes that he pointed out to you, claiming that he had worn them the night before, did they match the shoe pattern of the bloody shoe print at Bundy?
Overruled. Overruled.
No, they did not.
And you were attempting to also test them for blood. Is that why you took them into custody, sir?
That's one reason.
It is.
Okay. I'm sorry, Your Honor.
Slow down. We got all day.
That's what I was hoping to avoid. But, okay. Sir, why did you take those shoes into custody?
Because Mr. Simpson said he believed those might be the shoes he had on the night before. I wanted to determine the size of those shoes, and I wanted to determine whether or not they might contain blood.
And is that, so you took them, I think you testified earlier, to SID?
That's correct.
And what time did you take them in?
I arrived at SID the following morning at approximately 7 a.m.
Okay, what test did you request be performed on them?
A presumptive blood test?
And are you aware of the results of that test, sir?
Yes.
And what are the results?
Negative.
No blood.
That's correct.
Do you, excuse me, Your Honor, may I have one? You were asked earlier about a green piece of paper found in the grocery bag containing Ron Goldman's clothing that he wore at Mezzaluna on the night of June the 12th.
Time out.
Recall that?
Time out. I think we have to ask the Goldmans to step out.
Oh, yes. I'm sorry.
All right. Sorry, folks. Ms. Clark.
Thank you. Do you recall that, sir?
Yes.
And that green piece of paper, what did it look like to you?
Looked like a shopping list?
And are you presently aware of where that came from?
Yes.
And where's that?
Check the form of that question. He's presently aware. The question was, was he aware when I asked him yesterday? How did you heard on that?
Overruled.
I was approached by Mrs.
This is hearsay.
Sustained.
Do you know where it came from, sir?
Yes.
Well, he can say he knows where it came from, yes or no. What the answer is probably going to be hearsay. You're right. Says he can say yes or no, he's aware.
Yes.
Okay. Are you the source of that, sir?
No.
And the grocery bag in which the clothing was contained, did the police department provide that grocery bag?
No.
The clothes and the contents of Ron Goldman's apartment, can you tell us what was done with them?
As far as the clothing, most of the items of clothing were picked up by the family.
And so the family took the items of clothing?
Well, this is leading suggestion. That's not what testimony usually.
Sustained. Rephrase the question, please.
Who took the items of clothing out of Ron Goldman's apartment?
The Goldman family.
And you saw yesterday the clothing that was in the shopping bag?
Yes.
Okay. Was that clothing ever in police custody?
No.
Do you happen to know how that...
Strike that last sentence. That's vague.
Oh, well,
Do you happen to know how that clothing came into the presence of this courtroom?
haven't we already had testimony from Ms. Goldman about this? I think the jury knows where the clothes came from.
Okay. Well, then perhaps I should advise the court and counsel that the next witness will be Patty Goldman. Okay. Counsel? The next witness will be Patty Goldman. Sir, do you know what kind of shoe created the shoe print found, the bloody shoe
Excuse me,
print
Ms.
found
Clark.
at Bundy?
I'm sorry, are we done with the clothing
Yes, we are
aspect?
with the clothing
All right, Ms.
aspect.
Moran, would you invite the Goldmans back, please? Thank you. Ms. Clark.
Thank you, Your Honor. Are you aware of the type of shoe that created the bloody shoe print found at shoe prints found at Bundy?
I think you can ask, has he conducted investigation regarding the type of shoe?
Have you conducted investigation regarding the kind of shoe that created the bloody shoe prints found at Bundy, sir?
Yes, I have.
And what kind of shoe is that?
Say, Bruno,
Calls for a conclusion at this point. I think we're assuming facts that aren't in evidence at this point.
That's true. We're going to get to it, though.
Okay, well, let's,
We'll get to it in due time.
all right, I'll sustain the objection at this point. I'm sure we'll hear a lot about shoes.
That's true. I mean, we will. Sir, you indicated that, excuse me, you indicated that you did not diagram any of the blood on the rear gate at Bundy.
that's correct.
Okay. Did you create diagrams of the Bundy location, sir?
Yes.
And is that part of your crime scene notes?
Yes.
Did you diagram on those notes anywhere any of the blood that was found at the scene at 875 South Bundy?
No.
Now, you indicated that it was indicated in your notes that you saw 2 dimes and 2 pennies at the rear driveway of 875 South Bundy. You recall that, sir?
Yes.
You also reviewed all the photographs, did you?
Yes.
In any of the photographs, did you see 2 dimes and 2 pennies?
No, that's a mistake, and I erred in writing 2 down.
So that was a mistake you made in your notes.
That's correct.
All right. You're a human being?
Hope so.
All right.
That's self-serving.
Overruled. Overruled.
I do make mistakes.
Now, you indicated that you booked the change and that...
Mr. Carter. I heard the comment. I heard the comment. I heard the comment. Proceed.
You booked the change and the banana label, that label that you pointed out in the picture. You indicated you booked them on June 15th.
They were actually booked by the criminalist, yes.
Okay, were they seized on the 13th, sir, those
Yes.
items?
Yes.
All right, so tell us how that works. Why is it that it was seized on the 13th, but the paperwork shows booking on the 15th?
When the criminalist seizes an item, for all intents and purposes, it's in police custody and booked. It's just not administratively correct until a number is assigned and it gets placed into an environment and logged in. But as far as our purposes go, when the criminalist takes possession, it's in their possession, it's been booked. The other is just an administrative process.
Okay, so was it in the custody of the criminalist from the 13th when it was picked up at the scene?
As of the 13th, that's correct.
Okay. So what does the date of June the 15th reflect?
The actual day that it was logged in to property, when a DR number had been assigned and actual item numbers had been assigned to each item.
Did that mean that there was any change in the way in which it was being secured or kept?
Sustained, fleeting.
Does the, what is the date of, From June the 13th to June the 15th, with respect to those items, sir, or any of the items that we've talked about, does the date of June the 15th reflect any difference in the manner in which the item's being kept?
No.
Overruled. Overruled.
No.
So is there any custodial significance in terms of where the items are being kept in the date of June the 15th?
No, it's all in possession.
Custodial is kind of a vague question,
Yeah.
vague term.
I think so. Let me try and be more precise, Detective Lang. Is there any, does the date of June, what does the date of June the 15th reflect with respect to where the items of evidence are being kept or held?
Nothing. They're all in the possession of Scientific Investigation Division. That's just the formal logging in or booking of the items.
Now, you indicated that you did not diagram any of the blood at the crime scene at 875 South Bundy.
That's correct.
Why not?
That's not normally something that I would do. If there would be any diagramming at all or collection, that would be under the purview of the criminalist.
Okay, which would be Mr. Fung?
Yes.
Overruled.
All right, you indicated, sir, I believe earlier, that you booked the that little plastic heart that was found on the ground on August 25th?
That's correct.
Where was it before then?
It was secured at Robbery Homicide Division, Parker Center.
Okay, so what is the difference between being booked and being secured in the Robbery Homicide Division?
The difference is that it has not been assigned a booking number and it hasn't actually been logged in at Property Division.
What about the integrity of the item itself? Any difference there?
No, it would remain the same.
Deputy, seize that beeper, please. Deputy Russell. Thank you. Proceed.
All right, were you present when the blood sample was taken from the defendant?
Yes.
And where did it go after that?
It went into my partner's possession.
Detective Van Etter?
Yes.
And then what?
It's my understanding that it was transported.
Sustained.
Okay. Did you see it after the blood sample was drawn from the defendant and given to Detective Van Etter?
Yes.
When did you see it?
At the time it was withdrawn and turned over.
Okay. And after it was turned over to Detective Van Etter, did you see the blood, the vial of blood again?
No.
So were you around when that vial of blood was ultimately booked into evidence or into SID?
No, that was booked by criminalist Fung. I wasn't present.
Sustained. We'll strike the last part of the answer. The answer is no, since he wasn't present.
Right.
Proceed. Curious to disregard the last part of that answer.
So do you know when it was ultimately booked?
No.
Or by whom?
No.
All right, you were talking about hair and trace evidence. Remember that we talked about the knit cap that was found next to the glove under the plant at 875 South Bundy?
Yes.
And did you conduct any investigation to determine whether there was any hair or trace evidence to be found on that cap?
I personally did not. There was one conducted.
And are you aware of the results of that examination?
Overruled. He can say yes or no, he's aware.
Yes.
Was there anything about the results of that investigation into the hair and trace evidence in the knit cap that caused you to eliminate Mr. Simpson as a suspect?
No.
Objection, Your Honor. With respect, I'd like to put on object that hearsay in my intervention.
Let me see counsel at the sidebar with the court purpose.
Yes, Detective Lang, did you review the reports of the criminalist analysis of the hair and trace evidence found on the knit cap at 875 South Bundy?
Yes.
And engage in conversations concerning the results of that analysis, sir?
Yes.
And based on all of that, was there anything that caused you to eliminate Mr. Simpson as a suspect in the case?
No.
Seriously.
Overruled.
No, there wasn't.
Now, did you examine the reports of criminalists and experts concerning the analysis of the blood found on the glove at Rockingham, sir?
Yes.
And the reports that you reviewed,
All right, counsel, let me see you again at the sidebar. All right, thank you, counsel. Proceed.
Sir, after the was the Bronco found parked outside the gate, the defendant's Bronco parked outside the gate at Rockingham, seized on June the 13th?
Yes,
And was it submitted for testing?
that's correct.
And the glove found at Rockingham, was that seized on June the 13th?
Yes,
And submitted for testing, sir?
yes,
And the knit cap, was that seized on June the 13th as well?
yes,
And also submitted for testing?
yes,
And the blood, at the blood trail found at 875 South Bundy, was that collected on June the 13th also?
Sustained. Characterization is trail.
Okay. The blood drops found going on the walkway from the victims out to the alley behind 875 South Bundy, were those collected on June the 13th and submitted for testing?
yes.
Now, when was it that you submitted the case for filing?
June 17th.
By that time, sir, were you aware of the results of the testing of the blood collected at 875 South Bundy?
Yes,
And were you aware of the results of some of the tests conducted in the on the blood seized from the Bronco and submitted for testing?
yes,
And by that time, were you also aware of the results of the testing of the glove found at Rockingham?
yes,
And upon becoming aware of all of those results, sir, what did you do with the case?
I object to this.
Overruled.
Hearsay.
Overruled.
I presented the case to the district attorney's office to seek a filing.
All right, sir, before you left you were at Rockingham initially, is that correct?
Initially,
I
as
mean,
in-
before you went back to Bundy to do the actual crime scene investigation. I'm sorry.
That's correct.
Overruled. It's foundation.
Yes.
At the time that you left Rockingham to return to Bundy, what was your state of mind concerning what you thought was going to happen with a criminalist to respond to Bundy?
Right.
Sustained.
Well, did you call for another criminalist to proceed to the Bundy location when you left for Rockingham?
No.
Overruled.
No.
Why not?
Because it's my understanding that the criminalist
Overruled.
was to proceed to Rockingham and do a quick presumptive test on the blood that's on the door of the Bronco and then proceed directly to Bundy, so there was no need to.
Okay, so when you got to, when you went back to Bundy, what time was it?
I believe I arrived approximately 6:45 or 6:50 a.m.
And what was your expectation when you got there regarding a criminalist?
That the
Overruled.
criminalist would be forthcoming shortly.
Did you ever walk down that front walkway that leads from the sidewalk up to the steps at 875 South Bundy?
No.
Do you know who did?
Yes.
Who?
I object to this, Your Honor, unless it's a personal knowledge hearsay.
Sustained.
Did any member of the police department wash down that front walkway?
No.
To your knowledge, was the rear area and the rear gate area in the driveway of 875 South Bundy ever washed down?
It was not.
Now, after the investigation of the crime scene at 875 South Bundy was completed on June the 13th, how was the location maintained with respect to the gates?
Both gates were closed and locked, and the house itself was locked and secured.
How many units are there in that at 875 South Bundy, sir?
It's a duplex. There are 2 condos attached.
Okay, so Nicole and one other?
That's correct.
You indicated on cross-examination that there were reports of public people at Bundy. Do you recall that?
Reports of people?
Public people around the area of 875 South Bundy.
There were, yes.
Okay. And public, I mean, as opposed to police
about-
people,
Non-police, non-residents.
non-police, non-residents.
There were.
Are you aware of, you're aware of those reports?
Yes.
Okay, and Mr. Cochran discussed those with you on cross-examination, you recall?
Yes.
What area around 875 South Bundy did those reports pertain to?
Front of the location.
Like around the sidewalk?
Sidewalk, yes.
Do you have any, are you in possession of any reports that indicate that there were non-residents lurking around the rear area of 875 South Bundy?
Sustained. Calls for hearsay.
Are you aware of any reported incidents concerning non-residents around the rear gate area of 875 South Bundy?
Sustained.
Was there, the front and the rear gate at 875 South Bundy that we're talking about, do those give access to the other side, to the other duplex in any way?
No.
Who has access to those gates? No, do those, you know what I mean? Do those gates go solely to Nicole's condominium, or do they also allow access by other neighbors?
Strictly to the one condominium.
You have to recall, I think the jury's seen the walkway and the gates.
But it's been a while, so. Now, you indicated that you visited Bundy between June the 13th and July the 3rd,
Yes.
and do you recall why?
There were return visits to the crime scene to check on various things. I've never been involved in a crime scene investigation that I didn't return.
So, is that unusual for you to do, to go back several times to a crime scene?
No, on the contrary, it's very usual, and that's something that would be done at every crime scene.
Well, can you tell us why?
Because initially, there may be things that you've missed. You may want to return at a different time of day. You may want to recheck what you've already done. You may want to search for additional evidence. There are all sorts of things that could happen over a period of time. You may not catch everything the first time because there's a lot going on.
And so did that occur in this case?
Yes.
So between June the 13th and July the 3rd, where did you go? Where about that location of 875 South Bundy did you go?
See if we can narrow it down a little more time-wise.
Okay. Do you recall how many times you went back to the location between June the 13th and July the 3rd?
I believe it was 2 or 3 times.
Okay. On each of those occasions, those 2 or 3 times, sir, do you recall where you went?
Yes.
Where?
To the front of the location, to the area, the vicinity where the bodies were located, and to the interior of the house, examine the interior.
Did you ever go to the rear gate area on any of those occasions?
No.
When, after June the 13th, was the first time you went through the rear gate area?
I believe that would have been July 3rd.
And on July the 3rd, on the first time you returned to the rear gate area after June the 13th, which was, as you've indicated, July the 3rd, what did you see?
I observed a smear of blood. First thing I observed was a smear of blood on the upper rung of the rear gate that I had observed on June 13th. Additionally, appeared to be the same 2 droplets of blood on the lower rung of that gate.
The same two?
It appeared to be the same two.
The answer will stand.
Could you explain that, sir? You said the same two blood
It
drops?
appeared to be the same two blood droplets that I had observed earlier on June 13th on the inner lower rung of that rear gate.
And based on that observation, you did what?
Made an inquiry and requested Mr. Fung, the criminalist.
And were those blood drops on the rear gate submitted for DNA analysis, sir?
Yes,
And are you aware of those results?
yes I am.
Now, I think you indicated also that on August the 27th, you took the defense team, the defendant, and, excuse me, the defense attorneys and their investigators on a walk through 875 South Bundy. You recall that?
And they're criminalists, yes,
And their criminalists?
yes.
And I think you indicated on cross-examination that their investigator, one of their investigators, pointed out change inside the garage of the location of 875 South Bundy.
I believe there was 1 or 2 pennies lying on the floor of the garage.
And did you seize those pennies?
No.
Why not?
Those pennies were isolated from the crime scene. The garage door was secured at the time this occurred. There was no blood in the garage area. There was nothing to indicate that any suspect had ever visited that area or that had anything to do with the crime scene.
I don't respect this conclusion. It was their objection.
Overruled.
Okay, what do you mean the garage door was secured at the time?
It was closed.
It was closed.
Overruled.
The garage door was closed at what time, sir?
At the time of the murder.
Overruled. Counsel? Overruled.
Okay. And you indicated also, so where were the pennies were inside the garage, sir?
Inside the secured garage, yes.
And on August 27th, did you see any blood near those pennies, sir?
No.
Now, conversely, you indicated to the jury that you, earlier, I believe, that you found a dime and the penny on the rear driveway that you saw on June the 13th to be important.
To me it was, yes.
Can you tell us why?
The dime and the penny were in close proximity to the blood droplet in the rear alley that appeared to drop to me from a stationary source, indicating that source may have been standing still, reaching in their pocket perhaps for keys, and inadvertently dropping the coins going for the keys. The blood droplet had no tailing and appeared to come from a stationary source.
All right,
And so-
we're going to take our morning break at this point. All right, ladies and gentlemen, we're going to take a 15-minute recess at this time. Please remember my admonition to you: don't discuss the case amongst yourselves, don't form any opinions about the case, don't let anybody communicate with you with regard to the case, do not conduct any deliberations till the matter has been submitted to you. Stand in recess for 15. Examination by Ms. Clark. And Detective Lang, good morning again. You're reminded you're still under oath, Ms.
Sure.
Clark.
Sir, we were talking earlier about the Reeboks that the defendant pointed out to you on June the 13th.
Yes.
Okay, now I think you already testified that you took them at that point.
Overruled foundation.
You took them at that point from his closet, is that correct?
Yes.
All right, and then where did you go?
I proceeded down to the first level and out to my vehicle.
Do you recall, sir, about what time it was when you did that?
I believe it was approximately 6:15, 6:30 p.m., somewhere in there.
All right, when you left the residence, when you exited the house at Rockingham, did you see Mr. Fung anywhere?
No.
Did you know if he was even still there at Rockingham?
I don't.
Overruled.
I don't believe he was.
All right, now we were talking earlier about the, just before the break, about the walkthrough on August 27th with the defense team.
Yes.
Okay. Mr. Cochran mentioned something about a knit cap that was pointed out to you by one of the investigators, or the criminalist for the defense?
It was by Mr. Cochran himself.
Okay. And did you seize that knit cap that he pointed out to you, sir?
No.
Why not?
Knit cap was in the house on the upper level in front of one of the kids' rooms, and it appeared to be one of the kids' caps.
A child's cap?
Yes.
Did you ever ask that a tire track expert look at tire tracks in the rear alley behind 875 South Bundy?
No.
Two, please. P38.
All right, sir, do you recognize what's shown in P38 on the screen now?
Yes, it's looking in the alley in a northerly direction behind the Bundy location.
And is that the alley behind 875 South Bundy?
Yes.
Okay, now is that alley, is it cement or is it asphalt?
It's asphalt.
And you indicated just now, sir, that you did not ask that a tire track expert examine the alleyway behind the location of 875 South Bundy.
That's correct.
Okay. Could you please tell the jury why not?
It's a very commonly used surface. There are many, many tire tracks superimposed over one another, and there would just be no way to distinguish one from another.
And have you ever, well, when you were out there, did you look at the alleyway behind 875 South Bundy?
May I close objection with regard to this area that relates to the expertise of this witness? We're talking about two separate things.
Overruled at this point.
Did you yourself look at the alleyway behind 875 South Bundy?
Yes.
Were you able to observe any distinguishable tire tracks yourself?
Nothing distinguishable.
To your knowledge, sir, is there any way to tell when tire tracks are made?
Objection.
I don't know of any.
One of that question, beyond this, more foundation, this witness.
Sustained. Do you want to do a little more foundation with this detective?
Yes,
On
Your
tire
Honor.
tracks.
Sir, have you ever asked that tire track experts be called out to a scene to
Yes.
examine? And have you consulted and conferred with them concerning their findings at any particular crime scenes?
Yes.
On how many occasions, sir? Approximately.
There haven't been that many, quite frankly, 8, 10, maybe times the most.
And have you consulted with them about what they look for in tire tracks?
Yes.
And have you consulted with them about what they're able to tell you by looking at tire tracks?
Yes.
And have you ever, have they ever testified in any of the cases that you have prepared or conducted the investigations in?
Yes.
Based on your experience then with them, sir, are you aware of whether or not you are able to tell, they are able to tell whether, when tire tracks are made?
No.
Overruled. Overruled.
No.
No what?
I've never heard anyone be able to testify to the age of a tire track.
All right, sir. Now, you were asked also by counsel about whether or not any examination was done on the dog, Nicole's Akita, on his teeth to see if he had bitten anyone recently.
Yes.
Are you aware of any kind of examination that could ever tell you that?
I've never heard of one.
Now, you indicated that earlier on cross-examination as well, that the detective or Officer Hyder spoke to Sydney Simpson, that's the little girl of Nicole's daughter.
One of the officers did, yes. I don't recall the name.
And I think you indicated that you asked Denise Brown to speak to her, to Sydney?
Ladies, Ms. Cohen,
Mr. Foundace?
Oral.
Yes, I did.
Okay. Did you prepare a report of your request of Denise Brown to speak to Sidney Simpson?
No.
Okay, first of all, why didn't you write a report of that request?
The results of the interview were negative. There was no reason to.
Oral.
Okay, why didn't you have an officer speak to Sidney?
I was informed by Denise Brown that both children were under the care of a child psychologist, and that they not only thought it would not be a good idea for me to interview the children, but they would not permit it.
Does that continue to be the case, sir?
To my knowledge, yes.
Oral.
All right. Also, you indicated on cross-examination, sir, that you asked Detective Ron Phillips to speak to Officer Vasquez concerning Sidney Simpson and the contact that she had with the officers at West LA Station before she was picked up later in the morning. You recall that?
I believe so.
And you indicated on cross-examination that you made no report of Detective Phillips' conversation with Officer Vasquez concerning Sidney Simpson's behavior at the station. Do you recall that?
Yes.
Why was there no report written concerning Sidney Simpson's conversation or behavior at the police station?
There was nothing more to say. The report had already been written.
Can you explain that, sir?
The report was written as to the interview by the female officer. It went no farther than that. From that, I made an inquiry with the Brown family.
Okay. And then, so you attempted to follow up what was in that report through the Brown family?
That's correct.
I'm sorry. So, after you read that report, sir, what did you do?
I contacted the Brown family.
Okay. And you made some request of someone in the family?
Yes.
What was that?
I requested that Denise Brown and the family talk to Sidney regarding the statement.
And did they do so, sir, at your request?
Yes.
And as a result of having done so, what happened?
I received a call a few days after that from Denise Brown, and she stated that she...
This is hearsay.
Did the information you received from Denise Brown cause you to generate any further reports, sir?
No.
Or conduct any further investigation, sir?
No.
Or attach any significance to the report written by Officer Hyder and Vasquez?
No.
Sustained. Sustained. Curious to disregard the last question and answer.
All right. When you were at Rockingham, sir, I believe you indicated that you were nearby when Detective Phillips made the phone call to Chicago to notify the defendant?
Yes.
And who were you with at that time?
I was in the vicinity of Ronald Simpson.
Okay. Now, on cross-examination, sir, you indicated in response to one of Mr. Cochran's questions that Arnell told you that Mr. Simpson was in Chicago, but that she told you that subsequent. What did you mean by that?
Oral.
By that I meant that Arnell Simpson told me that after she made a telephone call to Kathy Randa.
Okay. Prior to the phone call that Arnell made to Kathy Randa, did you ask her the defendant's whereabouts?
I don't believe I did.
Did someone ask her?
I believe my partner did.
Okay. And what was her response?
Sustained.
Did she give you any information concerning where the defendant could be found?
Oral.
She didn't know.
No. That'll be stricken. Question is, did she give you any information, yes or no?
As to his whereabouts, no.
Next question.
When you were at the location, sir, at that time, approximately 6 a.m., did you go upstairs to look for Mr. Simpson or any possible injured victims?
No.
Why not?
By that time, we'd been informed that Mr. Simpson was in Chicago.
Oral.
I'm sorry?
Been informed that Mr. Simpson was in Chicago.
Okay.
There's no need to go upstairs.
So when you first entered the house, sir, how long did it take from the point of entry into the house with Arnell Simpson to the point when the phone call was made to attempt to locate Mr. Simpson?
It was a matter of minutes. Wasn't a long time at all.
Was there any search conducted prior to that phone call?
The only thing I did close to a search was I entered the housekeeper's quarters.
The maid's room?
Yes,
And why was that?
to check on the welfare of the housemaid if she was there or injured or whatever.
So what events transpired between the time you entered through the rear door and you made the phone call to try and locate Mr. Simpson?
I walked through the house, through the kitchen, into the maid's quarters. I checked that. I came back out. Arnell Simpson was in the kitchen area with Detective Phillips, and at that time they were making phone calls.
Now, when you entered the house, sir, who was with you when you first went in through the back door with Arnell?
Detective Phillips, and I believe Detective Van Adder was behind us with Furman.
I'm sorry, Detective Furman?
Yes.
Where was he?
He was behind us with Cato Kalin.
And then you entered the house, is that right?
Yes.
At the time that you were making that, Detective Phillips was making the phone call to, was on the phone with Kathy Randa and then later the defendant, was Mark Furman standing by you?
I don't believe he was.
When was the last time you saw Mark Furman prior to making the phone calls?
At the time I entered the rear of the house.
And after that point, did you see Detective Furman when you were at the time that the phone calls were being made?
I don't recall seeing him at the time, no.
When was the next time that you actually saw Detective Furman after you all entered the house through the rear door?
It was at the time that he approached me
And did what?
and asked me to step outside with him.
All right, now did you see Detective Furman have a conversation with Mr. Kalin?
Yes,
Now, were you and Detective Van Adder the lead investigators there that night?
yes.
So what did that mean in terms of how you guided the actions of the other officers present?
What did that mean and how it guided the other officers?
Yeah, were they allowed to just go ahead and do anything they wanted to, investigation-wise, at Rockingham or at Bundy?
No, they understood that we were taking over the investigation.
They understood.
Well, it's a conclusion by the witness as to what they understood. Once you're re-asking your questions.
What was your understanding, sir, of what their abilities to investigate and make decisions at Rockingham or at Bundy on that night?
That the decisions would be made by my partner and myself.
Okay. Now, did you see Detective Furman go in and speak to Mr. Kalin?
That's correct.
And did you approve of him doing so?
Yes.
And why?
We had more areas to check. Mr. Furman was in front of me and he knocked on the door. It was most logical that he speak to Cato Kalin.
And had you not approved of him going in to speak to Mr. Kalin, what would you have done?
I would have prevented it.
He knows what he would do, Your Honor.
Oral.
I would have prevented it.
Yes, sir, I'm going to ask you a series of questions about the cross-examination concerning the coroner. I'll show you some pictures.
Your Honor, this is going to be Exhibit 45.
All right.
All right, first of all, sir, you see that one white shoe in the bottom portion of the photograph?
Yes.
Are you aware of that? Do you have a recollection of whether there was any blood in the area of that white shoe?
There was none.
Next.
Exhibit 45C.
Again, you see the white shoe in the bottom of the photograph.
Yes.
Do you know whose shoe that is?
I believe it's a photographer, Mr. Rokar.
And do you have a recollection of whether there was any blood in the area where that shoe is in this photograph?
There was none.
Exhibit 45D.
All right, and you see the shoes in this photograph, sir?
Yes.
And are you familiar with the location, with the condition of the location where those shoes were on the night of June the 12th, early morning hours, June the 13th?
Yes.
Any blood in those areas, sir?
The only blood is...
The picture speaks for itself.
Or will anything that appears to you to be blood?
Okay.
Can we
Do you-
approach with regard
let
to
me-
this photograph? Because I think it's vague based upon the question.
Oh.
How can the photograph be vague?
Proceed.
Okay. Oh. Do you have a recollection of the appearance of the location where those shoes are shown in this photograph from your observation on the early morning hours of June the 13th?
Yes, it's a walkway above the bodies going west.
Okay. And do you recall, by looking at this photograph, where on that walkway these shoes are?
Yes.
Was there blood in that area, sir?
No.
I'm going to strike that answer in that area. That's vague.
Where the shoes are was the
Where?
question.
In that area?
Where the shoes are.
Well, that's suspicious.
All right. That's fine.
That's it. Yeah, thank you. You were also asked, sir, whether or not the hands of the victims were bagged. Do you
That's
recall
correct.
that?
That's correct.
Were they bagged, sir?
No.
Can you tell us, please, why not?
It's been my experience that one would bag the hands of a victim who's involved in a gunshot to be preserved for gunshot residue examinations. These hands and the entire bodies were preserved in plastic sheets. I'm not aware of any bagging of hands other than for gunshot residue examination.
Can you please explain to us, sir, what is gunshot residue?
Gunshot residue is powder or molten metal materials that could be part of a backblast from a handgun that could transform themselves on one's hand if they were in contact with a firearm if it went off.
So what will an expert detect if he examines the hands of a victim who has been shot or fired a weapon?
Exactly, Your Honor. Foundation, so you're saying.
Overruled.
Speculation.
Overruled.
Whether the possibility exists that that particular person would have been holding a handgun when it was discharged.
In this particular case, sir, by the time the coroner's investigator arrived, was there some determination made as to the cause of death?
Yes.
And what was that?
Slashing and stab wounds.
And was there a determination made with respect to whether or not any firearm had been used?
Yes.
And what was that?
In my opinion, none had been used.
So was there any reason to bag the hands of the victims?
I saw none.
Overruled.
I saw none.
Now, the entire bodies of the victims were bagged?
That's correct.
And what was the purpose of that?
To preserve any trace evidence or any other evidence that might be on the bodies to be examined at the coroner's office.
And would that procedure of bagging the bodies, what would that do with respect to any trace or fiber evidence that may have been on the bodies?
It would maintain it.
Now, the nail scrapings of the blood found under Nicole Simpson's nails,
Yes,
Yeah. Was DNA testing conducted on those scrapings, sir?
yes,
And are you aware of the results of those scrapings, the DNA tests on the nail scrapings?
yes, I am.
And did that testing reveal the blood to be hers?
Yes.
Sustained. Calls for hearsay.
This keeps a voluntary answer. You will
No.
strike that?
No. Calls for hearsay. Juries to disregard the last question and answer. Proceed.
With Did the results of the tests of the nail scrapings under Nicole Simpson's nails cause you to conduct an investigation into any other suspect?
No.
Now, you spoke earlier about wounds on the hands of Ron Goldman. Do you recall that, sir?
Yes.
And I think you also discussed scooped out dirt in the location that was near to his body.
Yes.
What, if anything, did that tell you, the wounds on the hands and the scooped out dirt?
During the autopsy, I observed contusions and abrasions to the rear of the hands of Mr. Goldman on the fingers and to the rear of the hand area itself. It indicated to me that he was probably involved in a defensive struggle, that he was attempting to fight back and that he was flailing his arms and his hands, very possibly running them into the tree or perhaps the metal rung fence or one of the stumps, sustaining those wounds. I observed very little abrasions or contusions directly over the knuckles.
What's the significance of that? I mean, why were you looking for abrasions or contusions over the top of the knuckles?
If one had abrasions or contusions directly over the knuckles, it would indicate to me that perhaps that person struck their assailant with a closed fist.
And did you see any evidence of that on the hands of Ron Goldman? That any evidence that would indicate to you that he had struck the person who attacked him with a closed fist?
Nothing to me that was overly significant. Again, there was quite a bit of bruising, contusions, and abrasions all over the hand, but most of it was on the fingers and the back of the hand.
Now, what about those keys? You found, you indicated earlier on direct and on cross that you found keys near the body of Ron Goldman. You recall that?
Yes.
Counsel was asking you whether keys could be used as a weapon. Okay. Now, first of all, sir, how many cases have you had involving murder by means of a knife?
By means of a knife?
Yes.
I'd say in excess of 100.
And how effective do you think a set of car keys or a set of keys would be to defend oneself against a knife attack?
I would.
It causes speculation.
I wouldn't think it would be effective at all.
Now, the fact that you found the keys by the body next to Ron Goldman, did that tell you anything with respect to whether or not those keys, in fact, were used in any way as a weapon or as a defensive measure?
I don't believe they were. I believe it indicates to me that there's a strong possibility Mr. Goldman was surprised.
Overruled.
Objective form is for the speculation.
Overruled.
I'm sorry, go ahead. Can you say that?
It indicates to me the strong possibility that Mr. Goldman was surprised in the attack.
And drop the keys?
Yes.
Is it,
Rephrase
and
the question.
as a result of being surprised, did what?
And drop the keys.
Something, sir, about the condition in which you found Ron Goldman. Can you give me?
Your Honor, you're going to need to cut the deed.
Yes.
Exhibit 43E.
right, sir. Look at the shirt of Mr. Goldman. Is that the condition in which you found him, sir?
Yes.
The shirt appears to be pulled up in that photograph, is that right?
Yes, it does.
What, if anything, did you conclude concerning the movements of Mr. Goldman based on the condition of his clothing and the position of that shirt pulled up as it is?
Not that before, but it's the foundation of the shirt.
Overruled.
That he was in a defensive struggle and that the assailant very possibly had grabbed that shirt and pulled it up to where you see it.
Was the shirt, were the sleeves pulled over his hand or the shirt pulled over his hand, either hand of Mr. Goldman?
I believe it was pulled down a bit.
Did you ever consider the possibility, based on your observations, sir, that Mr. Goldman was dragged at any point by the assailant at that scene?
I saw no evidence of drag marks, no.
All right, you were asked also about lividity on cross-examination. Do you recall that?
Yes.
Can you please explain to us what that is?
Postmortem lividity is the movement of the blood in the body to its lowest point after death, usually occurring within 2 to 3 hours, caused by a gravitational pull.
Now, what does lividity have to do with the time of death?
The time of death,
Well, without foundation at this point.
What does lividity have to do with the time of death?
It's without foundation, counsel.
Oh, I'm sorry. He heard your ruling and I didn't. That's. Sir, how many homicide cases have you had?
been involved directly or indirectly in approximately 250 investigations.
And in each of those cases, sir, have you had occasion to discuss the investigation with the coroner?
Yes.
And have you had discussions with the coroner in each of those cases concerning the subject of lividity?
At times.
Have you read articles or books about the subject of lividity?
Yes.
And have you heard testimony from coroners concerning the subject of lividity?
Yes.
Now, can you tell us, sir, what does lividity have to do with the time of death?
I know of none.
What is lividity used for?
Lividity can be used to determine whether or not a person was moved after they'd been killed.
And how is that determined?
As an example, if one were found in a supine position or on their back and lividity was present over the front part of their body, it would indicate that they'd probably been moved after death.
Was there any indication that either the body of Ron Goldman or Nicole Brown had been moved after the time of death?
I saw none.
And was any brought to your attention by the coroner at the time of autopsy?
No.
Now, when you made your observations concerning lividity, sir, where were you?
I was at the crime scene.
And I assume then you were that was based on your observations. It's going to be leading. You made observations concerning lividity at the crime scene, sir?
Yes.
And were the bodies of either Ron Goldman or Nicole Brown washed or unclothed at that time?
No.
Were they both clothed?
Yes.
All right. The blood that was in the walkway leading up from the sidewalk to the body of Nicole Brown, was there, the blood that trickled down? I think you indicated earlier you saw paw prints in that blood?
Yes.
Okay. Could you see, was there an obvious source to you of that blood?
The source to me was victim Nicole Brown.
Now, how many autopsies have you attended, sir?
Perhaps in the neighborhood of 150, maybe more.
Is it, whose job is it, sir, to determine whether or not stomach contents should be saved?
Coroner's office.
Overruled.
It's the coroner's office.
Are you a doctor, sir?
No.
Is it your job to tell them what to do with respect to whether you save stomach contents or not?
Sustained.
Have you ever told a coroner to save stomach contents or not to save them?
No. Overruled.
No.
Now, were you present at the autopsies in this case, sir?
Yes.
Did you observe what, if anything, the coroner did with respect to the stomach contents of Ron Goldman and Nicole Brown?
No.
You did not observe that?
No. What they did to them subsequent?
No, during the autopsy.
I observed the coroners examine the contents.
Of each, that is for Ron Goldman and for Nicole Brown?
Yes.
They did that in your presence, sir?
Yes.
And did they discuss the findings that they made based on their examination of the stomach contents with you?
I believe so.
Was there any indication that Ron Goldman had a full stomach at the time of autopsy?
Not objecting from this question. You're saying
Overruled. You was there. You were there when this was examined?
Yes.
Overruled.
I don't believe so.
Was Ron Goldman's stomach full at the time of autopsy, sir?
I don't believe so.
Based on the examination of the Well, let me ask you a different question. Why you indicated on cross-examination that you did not investigate the issue as to when Ron Goldman had his last meal. Do you recall that?
Yes.
Can you tell us why not?
It appeared to me that he had just left his place of business. The relevance just wasn't there.
Why not?
Because I wasn't aware that he'd had a meal. I was aware that he just left his place of business. It really didn't come into play.
Wouldn't it have helped you to determine time of death if you'd found out when he'd last eaten?
In that particular case, I don't see how.
Why not?
Because it didn't come into play. I was more concerned where he'd been prior to being killed.
Could you explain that? I don't understand.
Could I have that question again, please?
Sure.
Maybe I don't understand.
Yeah, I asked you why you didn't investigate into whether, what time he had his last meal. I asked you why you didn't think that determination would help you to determine more precisely the time of death.
Because I knew where he had been at approximately, I believe, 9:40 p.m. That to me was important. The meal wasn't. I knew that it was apparent to me that he'd gone home and changed and went to the Bundy location.
And what did that have to do with not investigating when he had his last meal?
What did that have to do with...
Right. Why did that make determining when he had his last meal less important to you? The fact that you knew when he left his place of work.
objecting from this question.
What did that have to do with it?
Overruled.
I'm sorry, could you repeat that?
Yes. I'm trying to understand why it became less important to find out when Ron Goldman had his last meal because you knew when he left his place of work.
Vague.
Do you understand? Hold on. Do you understand the question?
I don't know if I fully understand this. No.
It's vague.
Okay. It must be. You said that you... All right, sir. You were asked on cross-examination about questions about whether you investigated into to find out when Ron Goldman had his last meal in order to pinpoint his time of death.
That's correct.
Based on your experience in all homicide cases, how precise is the determination of time of death based on the analysis of stomach contents?
It's not precise.
I'm just on that. I'd like to hear on that.
Overruled.
Beyond the scope, there's no foundation, beyond the scope of this privilege is a petition.
Overruled. He said it's not precise. That doesn't tell us a lot either way. Ash will stand. Proceed.
In your experience, sir, and based on the prior homicide experience you've had, what is the most narrow time frame you've been able to be given by a coroner based on the analysis of stomach contents?
As to,
The relevant material as to what's happening, because I'd like to hear it.
Overruled.
as to time of death, I've never known time of death to be under 2 to 3 hours.
Okay. Now, I'm just talking about stomach contents.
Stomach contents?
Yeah, stomach contents alone.
I'm going to strike my attention.
Sustain. George, to disregard last question and answer. Non-responsive.
No. Based on your experience, sir, hundreds of homicide cases, how precise has the coroner ever been with respect to time of death based solely on the analysis of stomach contents?
Sustain. Sustain.
Has it ever been your experience that the coroner has been able to pinpoint the time of death based on the analysis of stomach contents?
Never.
That's what you suggested.
Overruled.
Form that question.
That's overruled.
Never.
Never?
I've never heard of that.
So when you determined that, did you make some determination based on your investigation as to when Ron Goldman was last seen alive
Yes.
by the public,
By the public?
by other people?
That's correct.
And when did you determine that to be?
Well, we already had testimony from the people from Mezzaluna Council. I mean, I'm making that point to Ms. Clark. Don't we already have that in the record when he was last seen?
This is just foundational, Your Honor, too.
All right. Proceed. I
Did-
think he's already testified to the time, though.
Yes?
Thought he said 9:40,
Oh, okay. Okay. Did,
about 3 minutes ago.
I'm getting lost in my own shuffle.
Okay.
Okay, you determined the time that Mr. Goldman left Mezzaluna, correct?
Approximately, yes.
Okay. And did you also determine from the first officer on the scene when his body was found?
Yes.
And what was the time lapse between those two times, when he was last seen and when his body was found?
Approximately 2 hours and 30 minutes.
What is the most, in your experience, sir, have you ever had a coroner testify to a precise time of death to the minute?
Never.
Form that question, right?
Overruled.
Relevant material, speculations, hearsay.
Overruled.
Never.
What is, in your experience, has a coroner been able to do in terms of time frame in any homicide case you've ever handled?
I object to what the coroner could do.
I think we ought to have the coroner tell us about this.
Well, Your Honor, it was gone into on cross-examination.
No, I understand that, but
This is the last question
the last question?
on this area. You know,
What's the last question?
on the coroner issue. What was it? What is, in your experience, what is the narrowest time frame the coroner's been able to give you with respect to time of death?
That's really vague, because that depends on so many different things. Each individual case is different.
Right, and that's why I'm just asking for, in his experience, what's the best
I
they've
know.
ever been able to do?
I think it's vague at this point. There's a 352 objection, because then he's going to tell us what the facts and circumstances are in that case.
Let me ask a different one then.
All right.
Let me try
Ask a
some-
different last question.
A different last question. Okay, you determined that there was a time frame of approximately 2.5 hours between the time Ron Goldman was last seen and his body was found. Is that correct?
Yes.
Has a coroner, in your experience, ever testified to a time range less than that as a time of death?
Sustained. Sustained.
Move on.
Mr. Cochran asked you on cross-examination several questions about what time the coroner was called. Do you remember that?
Yes.
Based on your experience, sir, if you had called the coroner at 4:30 when you arrived at the scene, could the coroner have told you whether the murder occurred at 10:15, 10:30, 10:15 versus 10:30 versus 10:45?
No.
Sustained. Hold on. Sustained. Juries to disregard the last question and answer.
Your Honor, can we approach?
Sure. All right, Detective Lang, when you hear one of the parties making an objection, would you please wait to answer the question until I've had a chance to rule on the objection?
Yes, Your Honor.
Ms. Clark.
All right, sir, if you had called the coroner at 4:30 a.m. when you first arrived at the scene, could you have allowed the coroner into the crime scene to examine and remove the bodies?
No.
Why not?
Because at that time, we hadn't completed our crime scene investigation.
You also indicated that you saw candles burning inside the residence when you looked inside 875 South Bundy.
That's correct.
Did you have any idea what time those candles were lit?
No.
Did you have any idea how big they were at the time that they were lit?
No.
How fast or slow those kind of candles burned?
No.
Do you happen to know whether you can tell a candle burning for 2 hours, how different it looks from a candle burning 2 hours and 15 minutes?
I would have no idea.
Right, you indicated that you did not consider the ice cream to be important, or you didn't consider it to be evidence. Do you
Overruled.
do you recall testifying to that in response to one of Mr. Cochran's questions on cross-examination?
Yes.
Do you
Overruled. Mr. Cochran. Overruled.
Can you explain to us, please, why you did not consider it to be evidence?
I was aware that small children lived at the location and that could very possibly be eating ice cream, leave out half-eaten ice cream. The cup itself was not in the vicinity of the bodies or the crime scene. It was in the rear of the location. It was in a secured area at the rear of the location. It was unclear whether it was melted or melting ice cream, but lumpy. Lumpy doesn't necessarily mean melted. And I just had no tie-in to what occurred in the front of the location.
Okay. Well, if you had if you had photographed the ice cream, would that have given us what kind of evidence would that be for us in terms of its melted or frozen condition?
Sustained.
Could you tell whether the ice cream had lumps in it?
Sustained. At this time? Which time? When he
Oh, I'm
looked at
sorry.
it, were there lumps in it? Had there been a photograph? Can you tell if there are lumps in it? Or is a vague question.
Shall I pick one of them?
I can think of three more.
Okay. When you observed the ice cream, sir, on the rear banister, did you notice whether or not it had lumps in it? or chunks in it?
Appeared to me that there might be a lumpy area in the center, yes.
And did you to conduct some investigation into what kind of ice cream it was?
Yes.
And have you ever heard of the kind of ice cream sold by Ben & Jerry's known as chocolate chip cookie dough?
Objective, Fung, that's being suggested.
It is. Sustained.
Have you heard of chocolate chip cookie dough?
What investigation did you do with regard to the ice cream?
Your Honor,
Well,
object.
I did that one.
Oh,
I showed you.
I just want to
You
move this
conducted-
along, counsel.
You conducted some investigation concerning the ice cream that was found in that Ben & Jerry's cup, sir?
Yes.
And did you attempt to determine what kind was in that cup?
Yes.
And what kind was it?
Chocolate chip cookie dough.
This one calls for speculation.
Sustained without foundation at this point.
How did you conduct that investigation? What did you do?
I contacted the Brown family and inquired of them if they would speak with the children.
Did you, based on that investigation, make an attempt to observe a particular kind of ice cream?
Yes.
That's vague.
Oh,
And what kind of ice cream did you pick out to observe?
Chocolate chip cookie dough.
And what did you observe about that ice cream?
That after it had melted,
oh,
it appeared to be lumpy.
You indicated, sir, in your grand jury testimony, it was pointed out something regarding the lighting on the porch at 875 South Bundy.
Yes.
You recall that?
Yes.
And you were referred to page 292. I'm going to ask you to refer back to that passage that was pointed out to you by counsel on cross-examination and ask you a few questions about that.
Maybe we don't.
I'm sorry.
We don't know.
Same thing, 292,
That was-
from line 16 down to the bottom.
certainly.
Thank you. Now, you indicate, tell me, sir, are these your answers in response to the following questions? Line 16, question, sir, when you arrived, can you tell me if you noticed the lighting in the front of the building there? Was there any? Answer, there was a porch light up the porch. Question, up on the landing? Answer, yes. Question, does that illuminate the walkway? Answer, yes. Question, in any effective way? Answer, it would have illuminated it some way. The lighting, I wouldn't say was excellent, but it was far from being dark. It was illuminated. First of all, sir, with respect to those questions and answers, you recognize those as having been posed to you and those being your answers at the grand jury.
Yes.
And what walkway are you referring to?
The walkway that proceeds along the north side of the residence, westerly, east-west, past the front entrance.
Are you referring to the walkway at the top of the steps, or the walkway that leads down to the sidewalk?
At the top of the steps, near the front entrance.
So the porch light that you referred to, sir, referred to in that passage, did it illuminate the bodies of the victims in any way?
No.
Did it illuminate the front walkway that goes from the steps down to the sidewalk at 875 South Bundy?
No.
Now, oh, maybe we should start the video. You were asked about an overlap in numbering, so I'm going to show you this again. All right, you see the numbers in, this is People's 53,
Yes.
115, 116, and 117.
Yes. And those, on People's 53 that you just looked at, 115, 116, and 117 were markers on blood drops on the rear gate? Yes.
Okay, and now on People's 48, you have markers of 115 and 117 on obviously these are blood drops, but they're not on the gate.
Yes.
Can you explain to us, first of all, the difference between a photo ID number and an item number?
Photo identification number, as it appears here in items 115 and 117, are for identification purposes of the item. The other numbers are for purposes of when they are booked into evidence. That's an evidence number that goes on the property report.
Now, the numbers shown in people's 48s, or what are these? Are these photo ID numbers or are they item numbers?
Those are photo identification numbers.
And are there reports that indicate that these are photo ID numbers shown in people's 48s?
Yes, that would be on the property reports.
And are the items marked in these photographs with photo ID number 115 and 117, have they been given item numbers that are different from those numbers?
That's correct.
And is that reflected in reports as well?
Yes, it is.
And are all these reports that you write, generate, you give copies for myself and defense counsel?
Yes, these particular reports were generated by the criminalists, but yes, they were turned over.
And then with respect to 48,
Objection to report, we have a report.
115 and 117 are, again, the photographic identification numbers as they appear on the property reports.
and is there a report that indicates what their item numbers are?
Yes, there is.
And do you know what their item numbers are?
I would have to look offhand, I can't tell you.
Would it refresh your recollection if you did look?
Yes?
Do you have something to do that with?
Yes.
Photo ID 115 is evidentiary item number 50.
Okay, so just a... All right, you're holding up, we're holding up now people's 48. Okay. The item that you pointed out, item 115, photo ID number 115 in people's 48G, what item number is that?
It's evidentiary item number 50.
And the blood drop shown in people's 53C that has the number 115, what is that? Is that an item number or photo
It's
ID
an
number?
evidentiary item number.
Okay. So what is marked as 115 in 53C,
Pleading suggested, Your Honor. You can tell us.
have a finished question.
Proceed.
The blood drop marked with the number 115 in 48G has what item number?
Ask and answer.
The item that, I'm sorry, I
Photo
was
ID
looking.
number 115 has what item number?
I believe it was item number 50. Item 50.
Okay. And the photo ID number item shown, photo ID number 117 goes to item number what?
52.
52?
Yes.
And 117, is that shown in the photograph I'm pointing to, 48I?
Yes.
And is there an item number indicated for the blood drop shown by the number 117 in 53F?
Yes, that's evidentiary item number 117.
Now, with respect to 116 shown in 53D, Can you tell us, sir, is that the item number or photo ID number?
It's the item number.
Okay.
One, please.
Okay. Now, do you see... Is this the mark? I'm going to ask this to be marked People's Next in order, 97.
All right, so Mark.
All right, sir, do you recognize, have you looked at the monitor?
Yes.
And you see the number 116.
Yes.
Can you tell us from your recollection, sir, where is that blood, where's the gate on which that blood is shown?
Objection, Your Honor, to state the blood, its conclusion, required witness to start the
Sustained.
question.
What appears to be blood?
There is an objection, sustained.
You can answer the question. What appears to be blood?
What appears to be
Re-ask.
blood?
Yes, that is on the front gate.
The front gate.
That's correct.
So is this a different item from the one, is this a different location from the one depicted in People's 53, specifically 53D next to you here?
Yes. That's a photograph ID number.
And is there an item number that goes with that photo ID number, sir?
Yes.
And what is the item number?
It's item number 51.
And what is the item number for what appears to be blood in the photograph marked as 53D?
Because the distinct, it's vague, you have a number. There's a number in the question.
What number is depicted in 53D?
Photo ID number?
No.
That's item 116. Is that what you're referring to?
Yes.
Yes. Yes.
Is there a photo ID number for the items shown 115, 116, and 117 on People's 53?
No.
No photo ID numbers?
No.
Those are just item numbers?
Yes.
But the blood shown on People's 97
Strike.
and
Very
People's 48, just that?
Rephrase the question. What appears to be?
Oh. What appears to be blood in People's 97 and in People's 48, do those what appear to be blood drops have item numbers that are different from the numbers shown in these photographs?
Yes, they do.
And those would be the item numbers you just stated, sir?
Yes.
Are there reports to indicate what the item numbers are for each of the items you've just described, sir?
Yes, there are.
And are there reports that also indicate what the photo ID numbers are for each of these items?
Yes.
And if one needed to straighten out any confusion about that, could one look at those reports?
Certainly.
Are there any items that have been recovered that have been given the same number?
No.
Does each item of evidence have its own number in this case?
That's correct.
And are there reports to indicate that, sir?
Yes, there are.
Would this be a good place?
Sure.
All right, ladies and gentlemen, we're going to take our recess for the noon hour. Please remember my admonition to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't have any conversations with anybody. Don't conduct any deliberations till the matter has been submitted to you. We'll see you back here at 1:30. Detective Lang, you're ordered to be back here at 1:30. All right? Not finished reading the file.
Your Honor, one matter that other counsel has asked me to raise, and there was some mention during the during the redirect of Mr. Lang as to the existence of some DNA results on the fingernail scrapings of Ms. Simpson, and I wonder if Ms. Clark can educate me and the other members of this side, because we are not familiar or aware of any reports or anything reflecting that, in fact, there have been DNA tests performed.
Your Honor, can we have Detective Lang step outside?
Why?
Ms. Carter?
He obviously already knows.
Well, it's about him. Step out.
He's the investigating officer.
Making a difference in this instance.
Well, this is a discovery issue, not a testimonial issue. Ms. Clark, is there any DNA testing results available regarding the nail scrapings?
Yes, DOJ has performed those tests, and I believe that the defense expert, Ed Blake, was present when they were performed. So I guess they're not communicating with their experts, but the results were that the DNA tests were consistent with the markers of Nicole Brown. And we're doing further testing now at Cellmark. As the court is probably aware, DOJ does D1S80 and
PCR.
Right. And Cellmark will be doing polymarkers just to further demonstrate that it is her blood underneath her fingernails. And that will be complete shortly, if it isn't already. But I know that the samples were completed at DOJ, and the results were consistent with Nicole Brown, and that further testing will be conducted at Cellmark, and I think it's already gone to Cellmark, but I'm not positive. Rock and Woody are here, Your Honor. If the court would like me to, I can call upstairs and get more definitive information on that.
All right.
Shall I?
Why don't you do that, and we'll take that up at the conclusion of the afternoon session.
Aren't they supposed to come to Your Honor, these results?
I assume that they did. I mean, I've got...
No, these results come to Your Honor, is what I'm asking.
No, to tell you the truth, all I do is log in what comes in and distribute copies.
Because you give them those right away, don't you?
Yes.
All right, so you have a copy.
How many lawyers are going to address this issue for the
Ms. Clark?
defense?
Well, Ms. Clark, have your assistants bring down that information so we can just double check to make sure we're talking about the same reports. You may already have it.
We don't.
Well, we'll check and see.
Okay. Guys, would you bring it down?
Turtello is here only because of the in-camera. Does the court have an estimation so he can be on his way? And
Well, Mr. Tortolo, as I indicated to you, I did not finish reading those materials over the lunch hour, but I want to go back into session with the jury, and I'll complete my examination of those matters this afternoon sometime, and I'll issue a written finding. All right.
Mr. Blazer, next step.
I think the confusion is over the EAP marker, which I don't, to our knowledge, there's been no retesting on that. That's the report that indicates it's not Nicole.
All right, well, Mr. Blazer, let's take this up after we conclude with the jury this afternoon.
That's right.
All right. All right, thank you, counsel. All right, Ms. Clark, what's your guesstimate as to how much longer we have?
Depending on the number of interruptions, it should be another half hour, 45 minutes.
All right, let's have the jury, please. All right, let the record reflect that all the members of our jury panel are again with us. Detective Tom Lang is on the witness stand. Good afternoon, Detective. You're reminded you're still under oath.
Shannon.
Ms. Clark.
Without the report.
Yes, sir. Mrs. Robertson? Do I want to? All right, thank you, counsel. Ms. Clark, you may continue.
Thank you, Your Honor. Okay. Detective Lang, you recall that a video was shown to you by Mr. Cochran during...
I'm sorry?
It's yours.
All right, proceed. And
Detective Lang.
Which exhibit is this, Ms. Clark?
Defense... That's 1043, Ron.
All right, proceed.
All right. You were shown this video by Mr. Cochran during cross-examination of the crime scene at 875 South Bundy. Do you recall that, sir?
Yes.
All right, first of all, in the frame shown to you right now, which is marked with a counter at the bottom of 1:11:33:07, do you see a white object in the background near the steps?
Yes.
And what is that?
That is the area of the body of Nicole Brown Simpson.
Okay, and who put that blanket on her body?
I did.
Did you touch her body in any way when you did that?
No, not myself, other than with the blanket.
Did the blood on her back and on her thighs appear to be wet or dry?
It was dry.
Okay. All right, you see yourself there, sir?
Yes.
Are you wearing gloves?
Yes.
Okay, did you see other points in the video when you were not wearing gloves earlier when it was shown to you by Mr. Cochran?
Yes.
And can you explain to us why you're wearing gloves at this point?
I am actually in the crime scene, doing my crime scene investigation, measuring evidence, measuring distances between bodies, this type of thing.
And when you were not wearing gloves, what were you doing?
I think it speaks for itself.
Oh, well.
You can see that.
Well, other things, other than the direct crime scene investigation, I was talking to people. When I walked through the house, I wasn't wearing gloves.
Were you collecting any evidence inside the house?
No.
At the points when you were not wearing gloves, were you collecting or dealing with any evidence?
No.
Now, you can see, do you recall stepping around the crime scene? You recall making those movements that are shown in the tape at this point?
Yes.
And what were you doing? Why were you stepping that way?
Stepping around the blood so as not to step in it.
I think this is the slowest slow motion I've ever seen.
All right, record should reflect that the videotape is being shown in what appears to be a slow motion and now stopped. Ms. Clark.
Yes, I'm waiting for the, we could speed it up just a little. Okay, can you tell us where you're standing, sir, at this point?
I'm standing on the walkway just to the east of the front of Nicole Brown Simpson.
Are you standing in blood, sir?
No.
Now, in this video, are you able to see your feet?
No.
Are you able to see the area where your shoes are touching the ground?
No.
Keep going. All right, what are you doing there, sir?
I'm measuring distances.
And you see the pair of legs in the white pants and the person in the blue, what appears to be the blue pants up on the landing?
Yes.
Are they standing in blood?
No.
And who are they?
The coroner's investigator and the coroner's driver.
Now, do you happen to know whether at that point there had been print people had done any work along the railings in that area yet?
Yes, I believe those railings had been printed.
Can you stop here, Jonathan? Okay, you see the, do you see someone up on the landing in a white coat there, sir?
Yes.
And can you tell us who that is?
Can't make it out.
Okay, keep going. All right, stop here. Okay, can you tell us, sir, first of all, the gentleman in the white jacket,
It's Mr. Rokar, the photographer.
and who is the man standing to his left?
I believe it's Detective Phillips.
And can you tell us where they are standing?
Not from that angle, no.
All right, we're looking
Can you-
at frame 12/22/13.
Thank you, Your Honor. Were there any news crews allowed inside the yellow tape on June 13th, sir?
No.
To your knowledge, what was the closest any of the film crews were allowed to get?
I believe they were all across the street on the sidewalk in the Parkway area.
So these shots we see are actually being filmed from across the street or in the street?
Or will,
That's correct.
And are you able to see the feet of any of these people or the ground that the feet are touching?
No.
So can you tell from these photographs whether they're standing on the grass or standing on the walkway?
I can't, no.
Stop. Can you now see? Can you now identify for us where Mr. Rokar are and Detective Phillips are?
No, Mr. Rokar appears to be in the upper left-hand, I believe it's Mr. Rokar and Phillips, upper left-hand corner portion of the photo.
And does this appear to be filmed from the sidewalk area across the street from the 875?
that's leading, but I think the jurors can
Can you see that?
see that, and since they've stood on that very place themselves.
That's true.
All right, this record should reflect this is frame 12/29/13.
Okay. Do you see yourself in this shot, sir?
Yes.
Okay. Okay, stop. I'm going too far. Keep going. Here. Okay, can you tell us what's happening in this frame, sir? This is 1/12/40/09.
It appears that one of the bodies is about to be removed.
And can you tell us who's standing inside the crime tape, apparently inside the crime tape? The three gentlemen with their backs to us in dark jackets?
Yes, so from left to right, Detective Phillips. Man in the center is Criminalist Supervisor Steve Johnson. To his right is Lieutenant Rogers.
Can you tell where they're standing with respect to the walkway, sir?
No, I can't.
Can you tell whether whether any of them are standing on the sidewalk as opposed to the walkway?
It's possible, but I can't really see from that angle.
The palm tree that's shown on the left-hand side of the photograph, sir, do you know where that palm tree is located with respect to 875 South Bundy?
Yes,
Where is that?
it's on the parkway to the front of the location, between the sidewalk and the street.
And do you see someone wearing something that seems to have white letters on the back?
Yes,
And can you tell us who that is?
it's the coroner's assistant.
And there's a gentleman in a white shirt just past him. Do you see that?
Yes.
Just above? And who's
Yes.
that?
I can't make it out from here.
Okay, keep going. Were you wearing a white shirt that day, sir?
Yes.
Stop. Can you tell us, first of all, the gentleman with his back to us in the dark trousers and the white shirt, who that is?
I believe it's possibly the commanding officer of the SID, but I'm not sure.
Okay. Can you tell where he is standing in relationship to the walkway, sir?
Appears to be on the sidewalk, but I can't see his feet, so I can't really tell.
Okay. And in the, just past him in the photograph, can you describe the three people that you see there?
Is the, inside the tape, and the man in the blue is the coroner's assistant. And over far to the left appears to be the photographer, Mr. Rokar. And above appears to be Ms. Ratcliffe, the coroner's investigator.
Okay. Stop. A little bit more. A little bit more. $49. Right. Okay. Okay, can you tell us, first of all, who is depicted in this photograph? And this is, for the record, 113-49-11.
I am pictured on the left. To my right and above me is Detective Phillips, and to his right is Mr. Rokar, photographer.
Okay.
Appears that Miss Radcliffe is bending over to the right.
Okay, that's the person whose torso is cut off by the right edge of the photo?
Yes.
And are you standing on pavement there, or are you standing in shrubbery?
I believe I'm back on the grass shrubbery area.
And Detective Phillips?
I believe the same, but I can't see from here.
And Rokar?
I can't tell.
Oh, could you back up, Jonathan? Just back up just for a second. Wait, stop. Ooh. A little bit forward. All right, can you tell now where you're all standing?
Yeah, it appears to be the grassy dirt area to the south of the sidewalk,
Okay.
or the south of the walkway.
Mm-hmm.
And that's frame 113-5405.
Thank you. Go ahead. Yeah.
The end of this particular
Okay. Okay, stop. Thank you. Okay, you see, you recognize someone there holding a brown paper bag?
Yes,
Who's that?
that's the criminalist, Mr. Fung.
All right, now at that point in time, sir, was he collecting evidence?
I don't believe so.
And do you recall what was in that brown paper bag?
Yes, there was a glove, I believe. This is the time where he showed me the glove from Rockingham that I wanted to see.
Okay. And you wanted to see the glove from Rockingham for what reason?
Wanted to visually compare it to the left-handed glove that I had at the crime scene.
Okay. And was that left-handed glove still... Where was that left-handed glove at the time that Dennis Fung brought the glove in the paper bag that you see in this photograph to you?
Still in position.
And why did you want him to bring the brown paper bag to you over where the left-handed glove was located?
I wanted to visually compare both gloves to see if there were a possibility of a match.
And what did you determine?
In my mind, they matched.
Now, how long was Dennis Fung at the scene?
I believe approximately 5 hours, perhaps longer.
Did we identify this frame?
I don't think so, thank you. 01, 18, 1800. Okay, after you determined that the gloves matched, sir, did you make any effort in your investigation to determine what size the gloves were?
Yes,
And what size did you determine them to be?
extra large.
Foundation, objection without further foundation.
Sustained.
All right, were you interested in... Sir, at that point, when you compared the two gloves, the one from Rockingham and the one from Bundy, had you had an interview with the defendant yet?
No.
After examining those, after seeing and comparing those gloves just visually, did you go and see the defendant at Parker Center?
Yes, later that afternoon.
Did you look at his hands?
Yes.
How big do they look?
Object before that question, and how big they look. It's vague.
It's kind of vague.
It is vague. Compare it to your hand, sir. How big did the defendant's hand look?
Object, that's again, it's relevant material. You want to see Mr. Simpson's hands, they're here. But object before that question. It's vague.
No, the question relative to your own hand, how big was his hand, that's an appropriate question. Doesn't tell us a lot, but
Well, it's-
Okay.
Large,
you can't-
much larger than mine.
Okay.
Much larger than mine.
And after seeing his hands, sir, did you attempt to determine through your investigation what size the gloves were?
Yes,
before that question.
Overruled.
Seeing his hands, object before the question.
overruled.
I'd already determined the size of the gloves.
And did the size of the gloves play a factor in determining whether or not to file the case ultimately on June the 17th?
Object before that question. That's relevant material.
Overruled.
I'd like to address that.
Overruled.
It was one of the factors, yes.
Let me ask you about something else, another factor, sir. The glove that you found at Bundy, you said, was that right or left-handed?
Left-handed.
When you saw the defendant on June the 13th, did you notice an injury to either hand?
Yes.
Which one?
The finger of the left hand, middle finger of the left hand.
Did that play any part in your making your determination to file the case on June the 17th?
Yes.
Now, if you know, sir, did Dennis Fung proceed, I think you indicated earlier that he proceeded to Rockingham first to do his investigation?
Yes.
All right. Do you know at what point you recall seeing him at Bundy?
Yes, it was approximately 10:10 or 10:15.
Okay. And then, do you know how long he remained at Bundy?
Several hours. Again, I believe it's approximately 5 hours, perhaps longer.
And how long do you see him in this tape? Of those 5 hours he spent at Bundy?
Oh, just a few seconds.
Object before the question. We haven't seen all the tape. That's it. That's a
All of
vague
this,
question.
all of this tape. All of this tape?
All of this tape, yeah.
You can answer the question. Tape pretty much speaks for itself, though, how long you see Mr. Fung on the tape.
Mr. Fung's on the tape for, appears just to be a few seconds.
Now, did he, after that, return to Rockingham?
Objection on behalf of his own personal knowledge.
I assume. Ms. Clark, rephrase the question.
Did you see Mr. Fung at Rockingham later on that day?
Yes.
Do you know what he was doing at Rockingham later on that day?
Yes.
What was he doing?
He responded pursuant to a search warrant at that location.
And did what?
Assisted.
Object without further foundation.
Ms. Clark, rephrase the question.
Did you see him at Rockingham? Did you see what he was doing?
Yes.
Where was he at
He was-
Rockingham? Inside or outside?
Both.
Did you see him inside the residence when you went back later on the afternoon of June the 13th?
Yes.
And what was he doing inside the residence?
He was conducting an investigation for evidence, in search of blood evidence.
Did you see him testing any blood stains out in the driveway at that time?
Well,
I-
what appeared to be.
What appeared to be?
I did not observe the driveway, no.
If you know, sir, did he complete the do you know whether Mr. Fung did his collection of evidence outside Rockingham in the morning before he went to Bundy?
Sustained.
In the afternoon, sir, when you saw him at Bundy, where was he primarily doing his work? I'm sorry, what did I say, Bundy?
You said Bundy.
I meant Rockingham.
He was inside the location.
Did you observe him conduct any testing in either the foyer or the bathroom of the location for blood?
Orwell.
I observed him conducting tests in the upstairs master bath.
What kind of test did you see him conducting?
Presumptive examinations for the presence of blood.
Okay. Keep going. Okay, can you see yourself in this clip right now?
Yes.
What are you doing?
I have my clipboard and I'm apparently jotting something down.
Go ahead.
That was 1836 on the last counter.
Thank you. Perhaps we can stop here. All right, you've seen the entire tape, have you not, sir?
I believe so. If the entire tape was shown in court, then I did, yes.
Okay. The activities that are shown there, you're present for most of them, are you not?
Yes.
Does this tape show the activities that occurred on the morning of June the 13th in sequence as they actually occurred?
Orwell.
I can't say that.
You can't say that? What do you
No.
mean?
In sequence is how things occurred.
Yes, is that how you recall things occurring?
Not necessarily. There were other things that occurred during that time, obviously. We're just looking at the front. It appears to be cut off from time to time. This
Let me-
doesn't appear to be continuous.
Okay. So there are things that took place that are not being shown on this video, on this tape?
Sustained.
Are there things that took place, is everything that took place being shown on this videotape?
No.
The numbers that are shown at the bottom there, sir, at this point, 119-04-10. Okay, do you recall when the coroner's investigators appeared and removed the bodies from the scene?
The coroner's investigator first arrived at approximately 9:10 a.m.
And do you recall what time was it approximately when they removed the bodies of Ron and Nicole?
I believe it was approximately 10:30, 10:40, right in that area.
So that number at the bottom of the screen, does that have anything to do with what time it was when those events transpired that are depicted in the screen?
No,
In
I
the
have no
video.
idea what it is.
And are you able to see the two gentlemen? We're stopped now at 119:04:10. There are two men in suits whose backs are to the camera. Can you tell where they're standing, sir?
No, not from that angle. Perhaps the sidewalk, but I can't tell.
You mentioned something about cuts in the tape, sir. What do you mean?
To me, this doesn't appear to be a continuous depiction of what occurred,
And why not?
because it's not continuous. There are areas where it's cut away. One view is cut to another view.
So do you think there are things missing?
Well, I don't know. Again, it appears to me to be from different angles.
Well, not Jeff, this is speculations. Tape speaks for itself.
Perhaps different cameras. I don't believe it's continuous throughout.
I think we've covered it pretty much now.
You're done. All right, you talked during cross-examination, sir, about shoe prints. At one point, you indicated that the bloody shoe prints at 875 South Bundy appeared to turn and face the condominium.
Yes.
And do you recall where that was in relationship to the front door? Did they turn in front of the front door?
No.
Where did they turn?
It's east of the front door, several feet east on the first level, above the bodies.
So if you're approaching from the walkway, if you're approaching from the sidewalk, going up the walkway and up the steps, how much before the front door did those shoe prints appear to turn and face the house?
I could only approximate 12, 15 feet perhaps,
12, 15 feet before the front door?
approximately.
And were there other did the shoe prints then continue after that like hesitation point facing the door, facing the house?
Sustained. Well, it assumes, makes an assumption. They turn it at an angle,
They
do they
turn.
continue beyond that?
Okay. At the point when after the shoe prints faced the house, turned and faced the house, did they continue?
They continued westerly, yes,
Was that in the direction down towards the alley?
past the front door, westerly towards the alley, yes.
Were they ever found to angle back in towards the house again after that 1 point 12 to 15 feet before the front door?
I didn't observe them, no.
Now, did you observe Dennis Fung conduct any testing for blood inside the Bronco at Rockingham on June the 13th?
No.
Did you attempt to open the Bronco on June the 13th?
No.
Do you know whether the Bronco was open or locked on June the 13th?
Overruled.
It's my information, it was not opened.
hearsay.
Do you know of your own personal knowledge, Detective?
When I observed the Bronco, it was locked, but I wasn't there for the entire time.
And when did you observe the Bronco in a locked condition?
The morning that I observed the blood on the door?
Were you present when it was towed away?
No.
Did you, at some point, the Bronco was opened, is that correct?
Subsequent to that, when it was examined, yes.
Do you know when and where it was finally opened?
Objection, use the word finally. Object does include the argument.
After leaving the scene?
Yeah. After leaving the scene.
After leaving Rockingham, actually.
Do you know when and where the Bronco was opened after it was...
That's simply fact, not evidence. That's simply fact, not evidence. The word was.
Well, it was opened at some time after leaving the Rockingham scene. Do we agree on that?
Before that. This matter was making open before that.
That's not what the testimony was, though.
All right. Why don't you rephrase the question?
Okay. Was the Bronco opened during the time that you were at Rockingham?
I didn't see it open.
Now, you left Rockingham at what time?
Approximately 6:40, 6:45 a.m.
Okay. And had the Bronco been opened at that point?
I never saw it open.
Okay. And you returned to Rockingham at what time?
That evening,
Yes.
approximately 5 p.m., maybe a little after.
Okay. Was the Bronco still there at the time?
No.
And when did you next see the Bronco?
I believe it was sometime later when we were doing other testing for blood.
I object to the answer.
And when...
I'm going to strike that answer. It's when you next see it. It's not responsive.
Overruled.
And when was that?
I don't recall the date. I believe it was in early August. I'd have to check. It was at in Impound Yard in Van Nuys.
Do you know where the Bronco was taken to when it was removed from Rockingham on June the 13th?
Yes.
Where?
I believe it was taken to the LAPD print shack.
Do you know whether it was opened there?
That causes speculation.
Overruled.
Subsequent, yes, it was,
Subsequent to what?
to the 13th.
When was that?
I believe it was the 14th or the 15th when it was examined.
Do you know how it was opened?
I believe it was a...
Unless he has personal knowledge.
Were you present when it was opened?
No, yeah.
Next question.
Now, did you indicated, I think, sir, that you personally observed that spot of what appeared to be blood on the, just above the handle of the driver's door of the Bronco?
Yes.
Okay. Can you describe for us the kind of grip of that door handle?
I would call it an outside left-handed grip
And why would you call it a left-handed grip?
because in order to open it, one would normally use their left hand because of the placement of the handle and the lock.
Object to that. President, there's an object to that.
Overruled.
And the defendant, when you saw him on the 13th, had a cut on the finger of which hand?
Left hand.
All right, sir, you indicated on cross-examination that you found no evidence to indicate that these were drug-related murders.
Objection, Your Honor.
Let-
Your Honor, that's not what the testimony was.
Sustained. Rephrase the question.
Okay. Do you recall discussing the subject matter of whether or not there was any indication that these were drug-related murders on cross-examination?
Yes.
Sir, have you ever worked on homicide cases that you determined to be drug-related cases?
Yes.
How many?
I would say perhaps as many as half of the number of homicides I've ever handled.
Which would be?
125, maybe more, maybe less.
Are there certain things that you have found in the course and scope of your experience in investigating drug-related homicides that you look for now, based on that experience, to determine whether or not drugs are involved in a homicide?
Object, Your Honor, object. Let me approach it.
Yes. Ms. Clark.
One moment. Okay, based on your experience, sir, and training, in your opinion, was the murder of Ron Goldman and Nicole Brown a drug-related murder? What's wrong with the form of that question?
Yeah, without the reporter. All right, the objection's withdrawn?
Yes, sir.
All right. Ms. Clark.
Based on your experience and training, sir, in your opinion, were the murders of Ron Goldman and Nicole Brown drug-related murders?
I do not believe they were.
Please tell us why.
It's been my experience that the vast majority of drug-related murders are carried out with a handgun or a firearm of some type. It's also been my experience that usually there will be evidence of narcotics usage or sales at the location, such as scales or debris from narcotics, something to indicate the sales or use of narcotics. It's also been my experience that when a
Wait, hold on,
residence...
sir. Did you find any evidence of drug usage or sales at 875 South Bundy?
No.
Go ahead, I'm sorry.
It's also been my experience in the murders that I've handled that the location, if open, will generally be ransacked because the victims are many times known to the suspects, and the suspects will ransack looking for information that might implicate themselves, such as their names, their phone numbers, telephone books, things of this nature. And also many narcotics murders, murderers will take money, drugs, weapons, or anything else that's available. It's also been my experience in drug-related murders that they're generally not committed in an area where it would be observed by the public. It would be in a secluded area or in a closed area. And the suspects are generally going to pick the time and location on their own. That's not going to be in an open area like this.
And so you found none of those indicators in this case?
That's correct.
Let me ask you, was the blood of Ron Goldman and Nicole Brown tested for toxicology to determine whether or not there were drugs present in their blood?
Yes.
And are you aware of the results of that testing?
Are you aware of the results, yes or no?
Yes.
Next question.
Did those results cause you to conclude that there were drugs involved in this case?
That is hearsay. Result is...
But-
It's a result, assuming a result.
It is.
We're assuming facts, not in evidence.
When you learned of the results, sir, of the toxicology, what, if anything, did you do to pursue the line of inquiry as to whether or not these were drug-related murders?
Sued at all.
Call roll.
Further statement.
Nothing.
Now, when you, in general, sir, when you investigate any homicide, do you consider all possibilities in terms of the motivation or why the murders occurred?
Call roll.
Certainly.
Okay. Did you do so in this case?
Yes.
And when you do that, and you did so in this case, what causes you to focus in any one direction?
Generally evidence or certain factors that may arise that point in one direction or another.
And did you follow the evidence to lead you to a particular theory in this case?
Yes.
And what is your theory of this case?
The theory of this case is that
Sustain.
In this case, the jury determined.
Sustain.
I thought that's what he asked about on cross-examination, Your Honor.
Well, with the reporter, please. All right, thank you, counsel. Ms. Clark.
Sir, without giving us your opinion as to the guilt or innocence of the defendant before the court now, did you formulate a theory as to whether or not this murder was perpetrated by one or two people?
yes,
And what was that theory, sir?
that was perpetrated by one person.
And what is that based on?
I observed one distinct set of bloody shoe prints between both victims, leading away from both victims west on the sidewalk, away from the location. Both victims were killed in a similar manner, slashing and stabbing wounds. Both victims had their throats slashed. I observed a drop of blood on the sole of the boot of Mr. Goldman. It contained a mixture of blood from both victims, indicating to me a cast-off,
Overruled.
indicating to me a cast-off of blood from one murder weapon.
Did you see anything to indicate to you, sir, that the perpetrator moved between the two victims?
Yes,
And what was that?
the bloody shoe prints, same distinct pattern that I observed going away from the location.
Next photograph from our People's Exhibit number 98. You want to make this next photograph be marked People's 98.
Yes.
And I recommend that you cut the food.
Thank you.
Could you please?
What's shown in this, this is People's 98? What is shown in this photograph, sir?
It's the sole portion of the bottom of the right foot of Mr. Goldman.
And can you describe for us, sir, where in this photograph you saw drops that appeared to be blood?
There are drops.
Oral.
There are drops of blood here, but this is not the one that I alluded to.
Okay. Next.
This next photograph being marked People's 99.
All right, People's 99.
And before you do, Jonathan, hold on. Where is Mr. Goldman being shown here?
This is on the walkway in front of the location.
Okay. And whose hand is holding the boot up?
Appear to be the coroner's assistant.
And who's standing in the background? You see someone standing
Appears to
wearing
be the coroner's investigator.
Claudine Ratcliffe?
Yes.
Okay.
People's 99. And your is the feedback?
Yes, it is.
Okay. Now, is this? Tell us what this photograph shows.
This shows the bottom of the boot of the left foot of Mr. Goldman.
Okay. And do you see in that photograph the blood drop, the mixture of blood that you referred to?
Yes.
And where is it?
They're in the center, in the white portion. It's not muddied.
Now, what does the existence of a blood drop like that in the sole of the shoe indicate to you?
It indicates to me that that mixture of blood is probably a cast-off from a weapon. As the weapon was being slashed or moved in some manner, that droplet was somehow slung off of the weapon.
And what does it tell you about the position of Mr. Goldman at the time that the blood was dripped onto the sole of the shoe?
It tells me that
It's on some fact not evidence. One minute question. Causes speculation also.
Yeah, phrase the question.
Did you form an opinion concerning the manner in which the position in which Mr. Goldman was when the blood was dripped onto the sole of the shoe?
yes,
And what was that?
he was down.
Now, sir, I think you indicated that after the body of Ron Goldman was removed from the location in which you observed it, where it was found in that small dirt area, you observed something that had been underneath his body? Do you
Yes.
recall that? And what was it that you observed, sir?
A ring.
Your Honor, I have here a manila envelope which currently bears seals. I'm going to ask that the detective break the seal and describe what he's doing. Sir, I'm showing you an envelope, a manila envelope, which is marked, imprinted with the title Analyzed Evidence. Do you recognize this envelope, sir?
Yes. It's an LAPD analyzed evidence envelope, item number 40.
And what is item number 40 in this case, sir?
The ring.
The ring?
Yes.
Is it currently sealed, sir?
Yes.
Could you please open the seal?
Yes. Taking his scissors, cutting across the top of the manila envelope, breaking the seal. Opening the envelope. Moving a small coin envelope.
And is the small coin envelope sealed, sir?
Yes.
Okay, could you please open that seal?
There are two packages. One is labeled scrapings from ring. Moving that from the top, I'll put that aside.
Okay, was that small package entitled Scrapings from the Ring, is that sealed separately?
Yes.
And you've removed it from the front of the envelope, the small manila coin envelope?
Yes. Now cutting the top of the small manila envelope with the scissors. Opening the envelope.
Okay, can you tell us if you recognize what you see inside?
Yes, that appears to be the ring that I observed at the crime scene.
We want to mark the envelope and contents, People's 100.
100. I wonder if the detective could step down and show the jury the ring by holding it on top of the envelope in this manner.
Is it possible to, may I see the ring? Thank you. I would suggest we pass it through the jury rather than the envelope, because the envelope may contain everything. All right, if you'll hand that to juror number 1, please. Can you retrieve that, please?
Just bring it up.
Yep. Ms. Clark.
Now, when you're at a crime scene, sir, you indicated earlier that you take notes of the crime scene, is that correct?
Yes.
Do you also, is it routine to have photographs taken at the crime scene?
Yes.
And what is the purpose of taking photographs at the crime scene?
To memorialize what is at a crime scene.
Is that another method of reporting what you find?
Yes.
With respect to the position in which items were found, or items that may have been moved from their original position, did you attempt to document that in photographs in this case?
That's correct.
And the photograph that shows the letter and the glove in their original position, you recall those photographs?
Yes.
Letter. Envelope.
And also,
Sustain.
the former use of the word original position, also conclusion.
Why don't you rephrase the question? It's compound. Assumes facts that aren't in evidence.
That's right. Do you recall being shown photographs of the envelope and the glove that were found at the feet of Ron Goldman, sir?
Yes.
And do you recall being shown photographs of those same items taken after the bodies were removed from the scene?
That's correct.
And did that, what did that accomplish, those two photographs?
The first photographs showed the evidence and the location that I first observed them. The second photographs showed those same items of evidence in a different position after the body of Mr. Goldman had been removed.
Ms. Clark, do you need the ring any longer?
I'm sorry?
Do you need the ring any
No,
longer?
we can put that away.
Perhaps we should have the detective replace the straight, I'm concerned about the straight envelope.
Put it back on. All right, now with respect to the videotape you were shown with the coroner's representatives in there and the photographer in there, tell us, in your experience, sir, 250 homicides, have you ever had a crime scene where the coroner investigators did not come in to remove the bodies?
Overruled.
No.
Do you know of any other way of removing bodies from the crime scene other than to have the coroner's investigators step into it and remove them?
No.
And the photographer, have there been photographers at every crime scene you've ever investigated, sir?
Yes.
Overruled.
Do you know of any way for the photographers to take photographs, accurate photographs of the evidence and where it was found without getting into the crime scene?
No.
Are these things, having photographers into the crime scene, the coroner's investigators in there, does this occur in every case, sir?
Yes, it's
Overruled.
a part of every investigation, yes.
Now, what dictates the manner in which you investigate a crime scene, the manner in which you document and collect evidence?
What dictates the manner?
Yes, what dictates what you do at a crime scene? Who you call in, when you call them in?
Vague. I want you to be a little more specific about what you're asking.
Okay. Sir, can you tell us, first of all, do you conduct your investigation at every crime scene in the same way?
I've never conducted a crime scene investigation the same way,
And why is that?
because all homicide scenes are different.
And what do those differences have to do with the manner in which you conduct your investigation?
Depending on how many victims, how the victims are found, the type of evidence at the location itself are all factors in how you'd handle an investigation.
Okay. So the circumstances that you found at 875 South Bundy, did they in some manner dictate how you conducted the crime scene investigation in this case?
Certainly.
Can you give us some examples?
As to Bundy,
Yeah.
Bundy was a close-in crime scene. The victims were close to one another. The evidence was close to the victims. Determination was made, as one example, to remove the victims prior to the evidence because of this. If the evidence had been several feet away or out in the street or something else, perhaps the victims would have stayed at that location while the evidence was collected. You just have to deal with what you have.
And with respect to this particular crime scene, I'm sorry. Did the physical distance that you had to work with in terms of the location of the victims and their proximity to the evidence pose any particular problem?
Certainly.
And could you explain that?
The closeness of the victims to one another, the closeness of the victims to the evidence.
And what did that cause you to do in terms of your investigation?
As far as conducting the investigation,
As far as collecting the evidence, as far as calling in the criminalists, the print people, etc.
well, one
Overruled.
was a determination that we would remove the victims prior to the evidence.
And why was that determination made?
Again,
I thought we've already asked and answered that.
All right, inside the house at 875 South Bundy, sir, can you tell us, first of all, did you notice any bloody shoe prints on the carpeting?
no.
Okay.
Overruled.
Okay, the fact that you did not find that, what did that mean to you?
Indicated to me that the suspect did not enter the location.
The knife on the counter, you had the photographer take pictures of that, you recall,
Yes,
on the kitchen counter? Did you make some determination as to whether or not you thought that was in some manner possibly related to the circumstances of the murder?
Objection, that's needed, just also covered on direct examination, not covered on improper redirect examination.
You know, it's been so long, I can't remember exactly. I thought we talked about on direct that there had been a determination that had tested negative for blood.
I remember that.
All right.
I thought there was cross on it.
I don't believe so.
Okay, withdrawn.
All right. Did not appear to be nicked or damaged or in any way. No blood on it.
I remember that. But,
And where it belongs in the kitchen.
and, right. That's, Right, Your Honor, I have videotape and photographs that I'd like to show the detective at this time. This was a video shown to the defense yesterday. Be asked it to be marked People's Next in Order, People's 101.
People's 101. Yes, with the reporter, please. To you. I have not seen them yet. So we're going to take our recess for the afternoon at this time. Please remember my admonitions to you. Don't discuss the case amongst yourselves. Don't form any opinions about the case. Don't conduct any deliberations or allow anybody to communicate with you with regard to the case. We'll see you bright and early tomorrow morning, 9 o'clock. All right, we'll stand in recess as far as the jury is concerned. As soon as the jury is cleared, we'll resume with 402 hearings regarding the videotapes. All right, don't go away. All right, back on the record. In the Simpson matter, all parties are again present. The jury is not present. Ms. Clark, do you want to show me this videotape?
Yes.
Do I have a feed problem with this tape?
No. People propose to show the video to the jury.
Let me just ask one other question. Mrs. Robertson, the hard copy photograph of that officer walking up the walkway, what defense number exhibit is that?
It's both. We have defense and people's. Was it people's 50-something, Deidre?
Well, when I said the hard copy, I meant not referring to Doug Bruckner, just... $57? $57. All right, I don't show in my notes the 57 was used with regards to Detective Lang.
No.
All right. All right, I have the printout from the videotape, People's 57.
Yes.
And my notes indicate that it has not been shown to Detective Lang.
No, it was not shown to Detective Lang. I would have done it myself on direct, but we had not yet obtained the video at that time that I conducted direct, and of course that was quite some time ago. And during the cross-examination, we were able to obtain that tape, and we will be providing the cameraman's testimony who shot the tape, who can indicate, number one, that the film that the court has seen depicts the activities as they occurred in sequence, although there are portions of activities not shown in between. The crime scene tape was the first event that took place, the taking down of that tape. Subsequent to that, the officers walked into the scene, and subsequent to that, we have the officer walking up the walk, which is the photograph shown by the defense initially to Officer Risky, I think, and Detective Phillips. The people proposed to use this tape to put the photograph that has now been shown to the jury into context. The inference that has been drawn throughout the testimony of all of the the inference that the defense is seeking to have the jury draw from this photograph is that the crime scene was contaminated, was not maintained, and that evidence was destroyed as a result of the manner in which the investigation was conducted. The people seek to demonstrate that the photograph shown and utilized by the defense for that purpose was misleading and out of context. And what this tape does is demonstrate just that. It demonstrates that the crime scene tape was taken down, the investigation had been completed, and it was only after that point that we have the still shot, and this is a still taken from that tape, as the court can see. It was only after that point that we have the officer walking up the walkway in order to place it in context. Because the defense has proceeded with that theory with Detective Lang's testimony through cross-examination, attempted to demonstrate that, once again, it was shoddy work and it was sloppy work and they did not maintain the crime scene. It's relevant, the people submit, in rehabilitation for
I
the work.
understand the relevance of why you want to pursue this. That's not the issue. The issue is whether or not it's appropriate at this time on redirect examination of somebody who's not been shown this photograph on either direct or on cross. And just so the record's straight, this is also Defense Exhibit 1011 in smaller format.
Then, and in response to that, Your Honor, if the court feels that the general attack of cross-examination on Detective Lang and the manner in which the crime scene was handled is insufficient to provide a nexus for the redirect I propose to conduct with this still and with the video, we would simply ask the court, leave of the court to reopen direct. If I had the video at the time of direct examination, I would have sought to admit it at that time with this photograph.
I'll hear from the defense.
The court has correctly pointed out that we never asked Detective Lang any questions regarding this. In fact, the only question the court allowed us to ask was, I think, with Risky some officers ago, whether or not he could recognize that particular officer. That's the only thing.
Because we had no foundation.
That's correct.
For the tape.
And that's all that you were allowed us to ask. We never asked this Detective Lang about that at all. In fact,
Now that I've seen the videotape, I'm very happy with that decision.
perhaps it was the right decision, Your Honor. But from the standpoint of what happened, I think that this is not the witness, as we've heard so many times with regard to, not the time with regard to that video. The appropriate time, if they can lay a foundation, then so be it. I mean, there are a lot of other things in that video also. But I think the point is, counsel talks about that scene being traipsed about, or our contention regarding that. We've demonstrated that with our own video of what took place contemporaneously with that, which they've asked questions about appropriately. And that's the way to go about redirect examination. Although we did see some cross-examination of that witness today also. But it seems to me that this was not appropriate at this point, and that's the point I was trying to make at sidebar, Your Honor.
Okay. Thank you, counsel.
Thank you. Your Honor, on another matter, something else I wanted to bring up after you rule on
I'm sorry,
this.
Ms. Clark,
Okay.
have you provided a copy of this videotape to the defense?
I believe we did.
No, we
Yes,
saw it.
we did. We gave him a copy.
We saw it yesterday, I think.
All right.
Your Honor, what concerns me is that no matter what purpose the court limited to, the court knows that it's very graphic evidence. And showing the jury that photograph did, I'm sure, accomplish the very purpose for which Mr. Cochran introduced it. He showed it to the jury, giving them the impression that despite the officer's testimony that care was taken to not contaminate and not destroy evidence, that in fact it did occur. And now Mr. Cochran's afraid that the jury's going to see this tape and realize they've been sandbagged. That's why Mr. Cochran's objecting, because otherwise he shouldn't. What he did was he took a photograph out of context and used it in very graphic manner to demonstrate something that was a complete falsehood.
Ms. Clark, forgive me for interrupting you at this point, but the issue really is, do I give you permission to reopen? That's the only question that I have to address at this point, whether or not somebody's being sandbagged or it's misleading. That's argument for the jury. It's of great interest to me in an abstract sense, but what I need to determine is whether or not I should allow you to reopen, since we all agree now that neither of these two were used with regards to this witness, correct?
Yes, of course, we do agree that,
All right.
Your Honor. I just wanted to ask the court to consider also that...
That's the only issue.
Would the court consider also the fact that when there's been impeachment in such a broad manner, on so many fronts in so many ways, all focused towards the demonstration of one thing, which is bad crime scene handling, that rehabilitation in this manner, in a general manner, to demonstrate that the focus of the attack has not been shown, that there has been some misleading indications by the defense in allowing Detective Lang to explain that, yes, people do get into crime scenes, and yes, ultimately the tape is taken down in response to the general impeachment that it has gone on with respect to specific categories, but the general theme. I mean, just because the impeachment didn't specifically go to that picture, I don't think that necessarily precludes us from using the picture and the videotape to rehabilitate the manner in which the crime scene has been handled by the LAPD. That's a sub-argument.
May I give the sub-response to that sub-argument?
Well, I mean, the real issue is, do I allow the prosecution to reopen to use this piece of evidence? That's the only real issue.
And
That's the point. All this other posturing and something like misleading, Your Honor, that's preposterous. All we've done is you allowed us to show the photograph and see if they recognize this person. We didn't know when that photograph was taken. There's all kind of representation. It was taken on the 15th. We know that's not true now. It was on the 13th. It was done
I
in good
never
faith.
made
And
such
then
a-
Just hold, Your Honor. May I conclude? With regard to this, counsel likes to make all these big speeches all the time. All we want to do is ask, Your Honor, they're asking to reopen. This was not with this witness, and all I've said, it wasn't with this witness. And that's the issue here. They can bring it up, they can use it with Van Adder, Your Honor. She wants to do it with the other officer. It's not us trying to hide all their witnesses, Furman, Van Adder, and Golden. We're not trying to do that. So the question about who's hiding. So the point is, Your Honor, is to make that decision, and we'll submit it.
Right.
talk about speeches.
Wait.
Where did Furman and Van Adder come into this? You know, counsel's amazing. I've never said June 15th. I've never said anything about this. I've always said the same thing, that the photograph was taken out of context, and now we can prove it's true, and that's what hurts Mr. Cochran. But it is the truth, and that's what we've got. The problem is that Detective Lang is the one who handled Bundy, not Detective Van Adder.
All right, thank you, counsel. All right, motion to reopen is granted. All right, we'll resume with our DNA issues.
A couple other issues so that someone's going to
Sure.
The court had asked us to
Point out to the court, with regard to the issue of the internal affairs investigation.
Yes.
I indicated to the court, just out of an abundance of precaution, because of Your Honor's spouse's occupation, I guess, after the first of this year, I thought the record should be made clear with regard to her involvement or lack of involvement with regard to these issues that have been raised on Furman, Mark Furman, today. And I indicated to the court we would do that, and the court suggested we should do that.
Right, my understanding is my wife has no connection with this investigation regarding Detective Furman.
Very well. Thank you for the representation, Your Honor.
All right, thank you, Mr. Cochran. All right, I was going to get a report from Mr. Hodgman and from Mr. Scheck regarding our status on microscopes and...
Well, I can report that I was asking Ms. Robertson whether a fax had come through. I know that Mr. Morton has located a laboratory that apparently has been upgraded of a criminalist named Carol Hunter, who I understand is in this area. And that he's checked with her. He believes she has the appropriate equipment. He's made arrangements, we've made arrangements to rent that laboratory Monday, Tuesday, Wednesday of next week to examine the trace evidence. And I had asked him to write a letter to the court.
Could we have it quiet in the courtroom, please?
Your Honor, I'm sorry to interrupt the counsel, but Mr. Hodgman needs to be here to speak on this issue.
You asked for a report on.
All right, well, I thought he was going to be here. Yeah, it'd be...
Well, in any event, Your Honor, just to make it clear, he's going to, I was hoping the letter would be faxed. I will have it faxed either by 5 o'clock to the court and to the prosecution the first thing in the morning, but I'm sure that's the nature of the arrangement, and I can notify Mr. Hodgman of that.
All right.
And I think that
Ms. Lewis, would you get me an ETA for Mr. Hodgman, please?
I'm doing that right now.
All right, counsel, do you think there's anything else we need to put on the record as far as that's concerned?
as far as that's concerned?
Yeah, I mean, I'll keep a court reporter around if you want.
No, I thought there was something with respect to the fingernail scrapings. I have an application with respect to
yes.
that.
Mr. Harmon, what's the latest on that? Good afternoon, sir.
Hi, Your Honor. When we're done with this, I'd like to get on the record.
Ms. Clark, do me a huge favor and stick around for this.
47, 50, and 78. As you know, I've been striving to get to the bottom of that for some weeks now. The fingernail scraping material is very simple, Your Honor. And Dr. Blake, I'm surprised he hasn't passed this on to the defense. Dr. Blake viewed the results of the DOJ typing a D1S80 on 3 of the scraping items.
Your Honor, I would object to this. I think the only question is whether or not a report has been produced.
Excuse me, Mr. Scheck, please, don't interrupt counsel.
My objection, Your Honor, is that if he's going to start announcing results in court before we've had a chance to see them, before they've been submitted to Your Honor,
Well, he was
that's
about to,
contrary to our
Mr. Scheck, have a seat, please. Thank you.
Thank you, Your Honor. At the completion of those tests, when we knew where the results were heading, we notified the court and counsel on February 16th that we were sending the extracted DNA from those items to Cellmark, and Mr. Clark is handling Cellmark, and he'd be glad to fill you in on that. But
All right, what about this preliminary result that's been communicated to Ms. Clark?
do you want to know what it is? I mean, it's no surprise. They're consistent with Ms. Brown. It's just her blood under her fingernails,
All right.
contrary to what Mr. Cochran said in his opening statement.
Has there been a report filed with the court yet?
No, Your Honor.
When should I anticipate that?
I wish I could tell you. They're still doing, I don't want to name all the other things they're doing again, but there's still a lot of other things that they're doing that are providing probative answers in this case. So at the pace that the trial is going, we're hoping that they finish everything so that they can write one more report. As you know, they wrote a very lengthy report. Once they start the report writing process, they can't do any more work. So I had tried to mention this a couple of weeks ago. It may be that because Mr. Simpson insists on his right to a speedy trial, that there will be no time to write a final report. And this is why Dr. Blake, going over there, photographing everything, seeing everything as it's unpacked, spending hours there, it shouldn't surprise anybody, but he probably won't be a witness in this courtroom. But he's seen all this stuff as it's unfolded in there. So there is no report. I can't tell you when one will be available, but the defense has had an opportunity to view these things as they're unpacked, to take their own photographs of these things, to take photographs of the results. He's there whenever he wants to be there. I think he's there a couple of times a week at least.
All right, Mr. Clark, you want to tell me about the status at Cellmark?
Sure, Your Honor. That testing is completed on the items that Mr. Harmon just described. Their report will be in the court's hands no later than Friday, most likely before Friday.
All right, this is the polymarker?
Correct. Six
PCR.
total, 6 genetic markers in total with regard to the fingernails.
All right, and that's already been verbally communicated?
Correct.
All right, Mr. Scheck. Well, we have to have a discovery issue here.
Your Honor, first of all, as a discovery matter, it seems to me highly improper for the prosecutor to be able to attempt to elicit, intentionally elicit, through this witness, testimony, A, that he's incompetent to reveal to the jury, and I'll explain why and how severely prejudiced we are by that, his testifying to this effect. He is not an expert on DNA. He is not an expert on genetic marker systems, and he's not an expert in. He has no personal knowledge as to how these tests were conducted, and that will be significant as this trial unfolds. Prosecution knows that, intentionally tried to elicit that evidence through this witness, knowing all of that. Number two, they intentionally elicited this testimony through this witness without giving us a report by their own admission. No report was given to the court, and no report was given to the defense. I would note that the process that Mr. Harmon, because he's apparently in charge of the Department of Justice testing in this matter, is pursuing, I think is contrary to the court's initial instructions as to how test results were supposed to be communicated. That is, his purposeful practice is to allow the Department of Justice to test significant items, such as the fingernails. They get results, but they don't send a report about those results. Instead, they're waiting until they finish all testing on various other kinds of items, and then at some point down the line, probably in the middle of his testimony from Mr. Simpson from the Department of Justice, then they'll give us a report. Now, that is contrary to the understanding I had as to how we were proceeding with the evidence in this case. That is, from the moment of the split hearing on forward, this court wanted to know what results were obtained by the lab with respect to specific items of evidence as soon as possible, because we were in this very unusual position that the prosecution is allowed to test whenever they want, in whatever process they want, at whatever speed they want, items of evidence in this case to time it to get a strategic advantage. And this is an example of exactly what they're trying to do. Now, Dr. Blake has communicated to me something about the fingernail scrapings with respect to how they were packaged and how this evidence is coming in. And I want to give the court a preview, and I think the court's already seen some of this with respect to this evidence. What we have, first of all, is a genetic marker test performed by Mr. Matheson of the LAPD of fingernail scrapings from one of 10 nails, I suppose, or maybe more than one of 10 nails. We don't know. We'll have to hear from him. There's nothing in the records to indicate which nails he scraped and what blood he took from which hand. That will be important, because there's no question that blood was under the nails of Nicole Brown Simpson, and some of that would undoubtedly be her blood. But as to which scraping from which nail might have revealed genetic material from another person with whom she was struggling is going to be a key issue in this case. They issued a report. Mr. Matheson issued a report saying that fingernail scrapings from some nail, we don't know which, or maybe more than one nail, came back on the EAP system as a B. In his report, he indicates that that excludes Nicole Brown Simpson, O.J. Simpson, and Ronald Goldman. There is a qualifier there that says, well, of course, if this was degraded, then maybe we can't test this result. Now, that's an issue that's going to be litigated with experts from both sides as to whether that's a real B or not, whether that's genetic material from somebody else under her nails or not. And the prosecution knows that very well, and everybody knows that very well, that that debate is coming. That's evidence of innocence. It comes out of their laboratory. The truth of the matter is, and they know it well, A, DNA test results from other nails that may be, have genetic markers that may have the genotype of Nicole Brown Simpson, it's, and would be expressed as some statistical estimate as to how rare that is, but some blood from some nail that may be hers is not necessarily relevant to this issue, number one. And number two, it is, of course, possible, more than possible, it is a scientific fact that it's possible for another individual who is not Nicole Brown Simpson to have an EAB genetic marker of B, hers is AB, and have a DNA marker that is the same as Nicole Brown Simpson's. So both of those issues are to be litigated and obtained. The prosecution knows that full well. What happened here is they, in violation of our discovery rules, in an attempt to gain a strategic advantage, purposely asked a question of the witness that was obviously beyond the witness's personal knowledge and expertise in order to bring that out before this jury. That was wrong. That is in bad faith, and we should get a curative instruction. The curative instruction that I would propose we draft carefully for the court's consideration for tomorrow would have to do to instructing this jury. It was improper to ask that question of this witness. Certainly, it was part and parcel of trying to take advantage of failure to turn over results in a timely fashion to the defense, and that it was misleading to the jury, and they should await the testimony of the proper witnesses to consider that evidence.
May I briefly inform Mr. Harmon on the technical issues concerning this matter? The Court is aware of the opening statement given by Mr. Cochran in which he misleadingly told this jury that blood marker EAP tested out to a B, which was inconsistent, and then highlighted a half a paragraph of the expert's work. The balance of the half paragraph that was never shown to the jury indicated clearly that this was not necessarily inconsistent with Nicole for the reasons that the Court is aware of the manner in which the BA type degrades. Mr. Cochran never told them that. Mr. Cochran, however, should have been aware of the fact that DNA testing was ongoing for those nail scrapings. He chose to stand up before this jury and give an opening statement based on half a loaf. He misled the jury as to what he did know and didn't tell the jury that there was other testing going on, and took the risk that that testing would absolutely refute everything he said. And he's now going to suffer for that risk taken, because the DNA testing has panned out exactly as expected. Of course, it's the blood under her fingernails. The people have done nothing wrong in eliciting from this detective, on a totally separate issue, the manner in which he conducted his investigation. The results have not been communicated to the jury through that witness, Your Honor. The only thing the detective testified to, as best I can recall, is that he was aware of those results and it did not cause him to change the focus of his investigation. That's an oblique reference. Nevertheless, it went towards the same avenue of testimony, which was in response to the cross-examination on that very same topic. But for counsel to get up and call this misconduct when their own expert knows very well what the results are, because he's standing right over their shoulders watching them do the testing, is absurd. If they don't communicate with their own expert, the people can't help them. You know, if they don't want to call the guy and ask what happened with this or what happened with that, if I was them, I would. Something like this where I stood up in front of the jury and made promises that I know might never be delivered, in fact, might come back to slap me in the face, I would be calling daily to find out what those results are. Counsel hasn't done that. I mean, that's the way he chooses to conduct his defense. That's fine. That's for him to choose. But to turn around and blame the people because testing that was ongoing at the time he made the representations and chose not to take into account in his opening statement have now come to fruition in the purview of knowledge of his expert is nothing to blame the people for. I don't see why the phone call wasn't made between them, but that's not something I can control.
But in terms of fairness and discovery procedure, though, I agree that the question to Detective Lang was rather oblique. After knowing that certain testing was done of the nail scrapings of Nicole Brown Simpson, and knowing the results of those tests, did that cause you to change the focus of your investigation? Pretty indirect way of saying those things. But it does, the kicker there, though, is that you said your question was knowing DNA results, which Mr. Cochran had said a lesser test had been used during his opening statement, so they're different things. And the question is whether, as a matter of discovery and fairness, you should be able to elicit from witnesses testimony regarding items that we have not gotten the reports back on regarding the test results. That's the issue.
Yeah, and I asked him about, I think I even confined it more narrowly to DOJ. Did I just say DNA? I can't remember. DNA?
Excuse me, counsel. My notes say DNA.
I defer to the court's memory, then mine is certainly not at its highest peak today especially, but I could find it, and I stated it that way because I know that Ed Blake, their expert, is standing and watching the testing.
All right, well, let's put the shoe on the other foot. Let's assume they're asking the questions and they get a similar question and answer without having turned over the report yet.
But if my expert is standing there and knows the result, I don't think I have anything to complain about. I don't think it's any different. They have their expert standing there, watching the testing going on, fully aware of what the results are, and now they're blaming us because they haven't communicated with him? I mean, that seems to me ridiculous. They certainly should have a system set up where they are communicating about what the results are, and that's why I thought there was no discovery issue with respect to this, because I know he's there privy to the results moment by moment as they come out. So how can this possibly be?
I'm having to make that assumption. You're asking me to make an assumption that Mr. Blake is aware of this and has communicated with defense counsel. You're asking me to make that assumption.
No, that's not an assumption. I think that the procedures put into place by this court with respect to testing at DOJ were that Ed Blake had to be notified and be present for all testing conducted.
He has to have access and he can watch it, but that doesn't necessarily mean that he knows what the results are.
How could he not? May I allow Mr. Harmon to address this aspect?
In any event, that's the issue. You're asking me to assume something.
Yeah, and I think that it's a fair assumption to make, and I think Mr. Harmon can better address this issue. But I will tell the court this. I asked the question in good faith, believing that the defense had to know of the result by definition if I knew of the result. But knowing that their expert had to be present for all testing, and that has slowed us down, by the way, immeasurably. knowing that he has to be present for all the testing.
All right, Ms. Clark, my inclination is to instruct the jury to ignore that question and answer.
Would the court hear from Mr. Harmon at this time?
Well,
There may be some...
But Ms. Clark, it's really a discovery issue. If we don't have a report that's been communicated to the court and then officially turned over to the defense, is it really fair for you to be asking questions about it at this point? Because in all likelihood, if the results are as you say, you'll be able to present that information to the jury at a later time, but to have done that through Detective Lang was probably not a fair way to do it at this point.
But that's what I'm trying to indicate to the court, is that the people I was acting in good faith.
I understand you're acting in good faith. I'm not questioning that. You had the information, and you believe that the other side also had that information.
Right.
That may or may not be true. You're asking me to make an assumption that Dr. Blake knows this and has communicated it with Mr. Scheck and Mr. Douglas. I don't know that.
Well, let me ask the court this. If Dr. Blake does in fact know the result, then where do the discovery obligations lie at that point? Once their expert knows, what are the people's obligations with respect to compelling him to tell them what the result is?
But our agreement has been that all labs doing testing communicate the results to me. And then I did, because of our leak problems, and then I disseminate those results to the parties, which has gone just fine.
It's been going well.
Because there have been no leaks since the first SOX incident.
And which has been good, but I really, please, may I ask the court to hear from Mr. Harmon on this? He does have
How is
information.
Mr. Harmon's comments going to change my view that our agreement was to have these things communicated to the court first? Mr. Harmon,
May I let him?
be brief.
I always have been, Your Honor. I wasn't here when this arrangement was set up. I understand the results were supposed to go to the court.
And they have. They've been...
As they have. What you don't realize is when I'm not here on Fridays, I'm up at the DOJ lab looking at things they're doing. And I'm seeing results. And I'm doing that so I can...
Mr. Scheck, let me just ask you
I'll
that.
tell you exactly what I know and what I don't know. I know that Ms. Clark just said something that was completely untrue. And she should know it, Mr. Harmon knows it, and he should tell it to the court.
Which
They
is?
didn't send any fingernail scrapings to be tested to the Department of Justice until after the opening statement in this case, long after. So when Ms. Clark gets up here and says, oh, we should know about this ongoing testing, and I'm in total good faith, to my knowledge, that's not true. Secondly, and this point has to be...
Mr. Scheck, no.
Well, she just said that, too.
Wait, everybody wants to get... I'm only interested in one thing.
Yeah.
Does Dr. Blake know about the fingernail
doesn't.
scrape testing?
He reports to me.
Yes, that's the only issue.
He reports to me things that he observes with respect to the testing. I knew that they were performing PCR tests. There's a big distinction that the court must realize here, and that is it's one thing to go and take a picture of a bindle that has powder in it and a set of fingernails, and go and take a picture of a strip. The necessity of a report, and I demand that they give us the reports on the items after they finish the testing on the items, so this doesn't happen. That was our agreement. Because I don't know whether the Department of Justice is saying that there was an EAB finding about a scraping on a fingernail that came from the left hand, or from a pinky, or from a forefinger, and then there's another DNA test result from a scraping from another fingernail. We don't know how they're going to interpret those tests. We don't know what they're formally saying their results are. You can't know and can't make an intelligent interpretation until you see it. And I would point out something to the court. An EAB test is a genetic marker. It is not a lesser test.
Mr. Scheck,
It is a
I don't
different
need to know
test.
this. I don't need to know this afternoon. All I need to
I
know
think you do.
is, does Dr. Blake know about the result that Ms. Clark mentioned, and has he communicated it with you?
He communicated to me certain results. I don't know about PCR testing, that they were testing the fingernails. Which markers, which nails, whether it was going to Cellmark, no, I did not have that, and we were awaiting reports from them. And I think I mentioned to the court in chambers that we wanted those reports. And it was the same problem we had before with Mr. Harmon, where he was telling people about reports on samples that hadn't been tested yet, and that's clear from the record.
All right, thank you, counsel. Let me just make this observation. I think as a matter of fairness, when the reason we have reciprocal discovery is so both sides know what's going on here. We're not just turning over cards blindly and not knowing what they are. I don't think it's appropriate for the prosecution or either side to ask questions regarding scientific testing that hasn't been completely revealed to the other side. That's our understanding. So, Mr. Scheck, if you'll offer an instruction regarding that question and answer, but I think it is not nearly as broad as you seem to recollect. My recollection of the testimony is that it is a relatively oblique question and answer.
I saw
But-
I'll review the transcript.
Well, seeing it on TV and seeing it here live is two different things, as you know. Okay, so I will expect those results hopefully by the end of the week.
I do have that letter from Mr. Morton, and I'll have copies given to the prosecutor.
All right, have you and Mr. Hodgman had the opportunity to speak about this new lab that you've located, the facilities, and the ability to test locally?
No, I just got this from Mr. Morton at the court's request yesterday, so this only concerns the trace evidence.
Okay. Let me do this. Let me stand in recess then for about 15 or 20 minutes. Let me have Mr. Hodgman and Mr. Scheck confer about Mr. Morton's scientific testing. I think Mr. Cochran, Mr. Douglas, we're going to stand in recess, and I'll confer with the DNA people in chambers, and I'll keep a court reporter around. I need to meet with Judge Jaffe, so I'm going to let you all go. All right, we'll stand in recess. Yes.
47, 50, and 78, can we take that on the record for the first time?
I'll keep a court reporter here.
Your Honor, very quickly, you told us to have it back by the end of the week. We will
Yes.
have it back by the end of the week.
Okay, well, the other attendant issue that came up in chambers when I mentioned it was, I want some assurance that the provisions that you made in your court order of February 8th, that we're entitled to explain to the trier of fact that they have
If there's
consumed
something
part of it in
missing,
testing.
Yes, but let's see what comes back.
Okay.
Let's see if they've done anything to it, and we'll cross that bridge if and when we get to it.
Can I ask the court's guidance in one matter, because I think I need to understand this, so this doesn't happen again. As I understand, Mr. Scheck has admitted to the court that he knew of the results from DOJ on the
He said he knew
fingernails.
there was testing. He doesn't know what it was, which finger, which fingernail, which pile of scrapings, what finger.
Didn't he admit that he knew the results of the testing, that it was an 1818, which is at
No,
Nicole Brown?
in fact, that's not what I know.
No,
In fact, I thought it was PCR, DQ alpha testing.
no. He needs to know what you're talking about when you're asking questions about it.
I agree.
Okay.
I agree. So perhaps it is the rule at this time that there has to be a report, a written report in everyone's hand, or a conference at least to indicate that everyone knows.
I realize that a lot of this stuff is ongoing. Both sides ought to have the same information regarding scientific testing results.
Oh, I agree. I really do.
Your Honor, my proposal to make sure that this doesn't happen again is that after they finish testing on a particular item and get a result, they write a report immediately to the court. That's how we were proceeding.
I don't know that that's necessarily practical, but
Well,
we'll cross that. We're not there yet.
Okay.
All right. Draft your instruction. I'll see the lawyers and everybody else at 9 o'clock tomorrow morning. And Mr. Hodgman, Mr. Scheck, after you finish conferring, I'll be available. And Judge Jaffe, can I see you in chambers, please? All right. Thank you.